I'm going to get the live stream started. I'll just give it a second to make sure we're running.
It looks like it's up now.
All right, you are good to go.
All right, thank you, Elliot. Okay, I guess we can get started if the competitors, the attorneys would all turn their videos on so they could introduce themselves. And if we have whoever the other judge is, if you'd like to just sign on for a second, just so we could all have everyone see your face. Yes, hello. All right, so I'm seeing 2 from the defense, 1 from the plaintiff. All right, I think, is this everybody? All right, I guess we could started if we could just have the attorneys for the plaintiff introduce themselves.
Yes, Your Honor. Good afternoon.
Good afternoon.
My name is Kathleen Skura, and I'm joined today by my co-counselors, Ms. Shelby Johnson.
Good morning, Your Honor.
Good morning.
And Mr. Krishna Kanduri.
Good morning, Your Honor.
Good morning. Welcome, everyone. Thank you for being here. And now, who do we have here on behalf of the defense?
Good afternoon, Your Honor. My name is Laura Parsons, and myself, along with my co-counsel, Vinayak Kuru.
Good afternoon, Your Honor.
Good afternoon.
And Logan Colson.
Good afternoon, Your Honor.
Good afternoon. Thank you for being here.
We are representing Peony Estates today.
All right. Thank you. And I see we also have Judge Baraki here with us as well. Did I get that right?
It's close enough. That works.
I'm sorry.
No, you're good.
All right. Well, I guess now that we've got everyone here, it looks like we can get started. Before we start with opening statements, are there any pretrial matters? I'll ask first the.
Yes, Your Honor. Today, Ms. Johnson and Mr. Kanduri and I are advocating on behalf of the plaintiff, pardon me, the estate of Genesis Petria. Your Honor, since this is the first time we've appeared in your courtroom, we'd like to bring up a few housekeeping issues. First, would you prefer that we request permission prior to displaying exhibits and demonstratives for yourself and opposing counsel?
Yes, if you just let us know that you're about to do that. But I'll ask opposing counsel if defense does it. I'll ask to see if there's any objection. But if you just give us a heads up that you're about to be sharing the screen, so we're aware. Thank you.
Yes. May we presume also that exhibits are constructively displayed out of the visibility of the jury until they are entered into evidence?
I'm sorry, could you repeat yourself? I'm getting a little bit of feedback. I couldn't.
Sure. May we presume that exhibits are constructively displayed out of the visibility of the jury until they are indeed entered into evidence?
Ms. Parsons, it looks like you're the representative on behalf of the defense on this matter. Do you have any objection to that?
I have no objections, Your Honor.
Then, so allowed, we will assume that all exhibits will be heard outside the presence of the jury.
May we also presume that all objections and subsequent arguments are constructively heard outside of the earshot of the jury?
Yes.
We'd like to verify, Your Honor, that you have been provided with a bench book.
Yes, I have.
And at this time, we would invoke Rule 615, constructively sequestering all witnesses save for party representatives. As the plaintiff, we have no party representatives.
Yes. Mm-hmm.
Additionally, we would invoke Rule 603, all witnesses are pre-sworn before trial.
Yes, we'll just assume that all witnesses have been sworn by the time they begin their testimony.
Very well. And with respect to the elements of negligence per se, I'd like to point Your Honor's attention to the September 30th pretrial order, specifically Section 3 on vicarious liability, where the defendant, Peony Estates, is held vicariously liable for the actions of Harper Martini, Austin Lewis, and all employees of Peony Estates.
Does defense counsel wish to be heard with regards to that motion?
Not in regards to that section of the pretrial order, Your Honor.
All right, then, yep. Do we have any further pretrial motions from the plaintiffs?
Indeed, thank you. We want to please bring your attention to Midland's case law, specifically Wandro v. Conforth, in which the court ruled on the elements of negligence per se. it's been stipulated by both parties that elements 2 and 4 have already been met. So in contention today are elements 1 and 3, that the defendant violated safety statute 12100, and that the defendant's acts and/or omissions caused the type of harm that the statute was intended to prevent. I'd also like to draw the court's attention to Kaplan v. Sikora, which states that pursuant to Rule 801 D2D, a statement that would otherwise be hearsay is admissible against a party if the declarant is the party's agent or employee. The statement concerns a matter that is within the scope of the agency or employment relationship, and if the statement was made while the agency or employee relationship existed. And with that, Your Honor, we're ready to proceed.
Just before, does defense counsel wish to be heard on that last matter?
No, Your Honor.
And that's all been settled, it appears. Do we have any pretrial matters from, and you said that was your last matter?
Indeed, yes.
Yes. Do we have anything on behalf of the defense before we begin with opening statements?
Yes, Your Honor. Just a few points. First, we would like to draw the court's attention to stipulation 3, which states that exhibits 1 through 10 have already been pre-admitted into evidence.
Yes. So once you go to introduce anything, just if you could remind the court that they've already been stipulated to and they shall be entered.
Yes, Your Honor.
Mm-hmm.
And secondly, we would like to draw your attention to the second point of the negligence per se pretrial order, which states that the trial is limited today solely to the issue of liability, and any evidence that relates solely to damages is inadmissible.
Does plaintiff's counsel wish to be heard on that matter at all?
No, Your Honor.
Thank you. Anything further from the defense?
No, Your Honor, the defense is ready to proceed.
All right, I guess we are ready to start then. If we can have whoever from the plaintiff's counsel will be giving the opening statement. And I believe you guys will be keeping your own time, is that correct?
Yes, Your Honor.
Yes, okay. So Ms. Skura, I guess it looks like you're gonna be delivering the opening statement. You may begin whenever you're ready.
Thank you, Your Honor. It will be my co-counsel. Thank you.
Okay, Ms. Johnson, whenever you're ready, you may begin.
May it please the court. Another year, another inspection, another excuse. Members of the jury, today we're here to discuss what happens when a business fails to adhere to safety precautions. Today, you'll hear about a local winery in Midlands called Peony Estates. Peony Estates is owned by Ms. Harper Martini, harvests grapes and produces wine, all while functioning as a bed and breakfast. You'll learn that Peony Estates encountered numerous pest infestation issues with staggering losses in profit. But the state of Midlands has set rules and regulations in place for pest control. Statute 12100 protects consumers from the contamination of their food and drink from pesticides. But you'll learn that Peony Estates over the years has repeatedly failed to adhere to such guidelines. Pesticides have been found both inside the production facilities and inside the kitchen. Peony Estates has failed numerous health inspections because they never properly fixed issues as they arose. And unfortunately for the public, the situation got out of hand. Today, you'll hear about a young woman named Genesis Petrillo, a woman who didn't get to walk down the aisle after drinking a bottle of Peony Estates' wine at her rehearsal dinner on the night of June 7th, 2019. A woman whose life was cut short as a result of Peony Estates' failure to follow precaution. Testimony will show that the safety hazards within Peony Estates were a pattern that began in 2016, 3 years before Ms. Petrillo's death. You'll see that the years of constant mismanagement led to the mix of wine with pesticide and the loss of a young woman's life. There were precautions. There were preventable measures in place to avoid such harm from coming to consumers. A winery is supposed to establish an enjoyable experience free of doubt about safety. It was Peony Estates' responsibility to carry out those measures. And had they done so, Ms. Petrillo would still be here with us. Today, we'll show you this through the testimony of 3 witnesses. First, you'll hear from Mr. Danny Francasio, Ms. Martini's former employer. Mr. Francasio will walk you through him and Martini's history together, and he'll talk to you about the multiple times that Miss Martini approached him asking for advice about the out-of-control pest infestation at Peony Estates. Next, you'll hear from Miss Lonnie Paris, a local journalist. She'll tell you about her investigation into Peony Estates' mishandling of pesticides. And she'll tell you about the pattern of Peony Estates' improperly storing pesticides near their products. Finally, you'll hear from Inspector Riley Atkins O'Keefe, a health inspector here in Rapid River Valley. He'll talk to you about his inspection of Peony Estates, and he'll tell you about the health code violations with which he cited the winery. Members of the jury, we bear the burden in today's case. We must prove by preponderance of the evidence that the defendant violated Safety Statute 12100, that the defendant's actions caused the type of harm that the safety statute was meant to prevent, and that the defendant's actions were both the direct and proximate cause of the plaintiff's harm. Now, members of the jury, throughout today's case, I want you to keep it in mind that phrase, direct and proximate cause. It means that but for Peony Estates' actions, Genesis Petrillo would still be here with us. The testimony will show that Peony Estates violated that Midland safety statute, and such failure led to the death of Genesis Petrillo, a tragically preventable death. Evidence will illustrate that Peony Estates was knowledgeable about the safety regulations, yet chose to improperly handle and store their pesticides. Today, you'll see that another year, another inspection, and another excuse led to the negligent practices at Peony Estates that killed Genesis Petrillo. And at the end of today's case, my co-counselor, Krishna Cannery, will come before you, and he will ask you to find Peony Estates liable of negligence per se. Thank you.
All right, thank you, Ms. Johnson. If whoever is keeping time for the plaintiff, if you could at least just put in the chat how much time that was left. I don't know remaining for the closing. I didn't have a clock on that. And now it looks like we have Mr. Kurup, who's going to be opening for the defense.
Yes, Your Honor. Can you hear me all right?
Yes, I can. Thank you.
Okay.
So you are free to start whenever you're ready. Thank you.
May it please the court, counsel, members of the jury. I want to take you to June 2019. Casey Soto and Genesis Petrillo, they're planning their wedding, putting the last finishing touches on this moment of celebration. June 8th rolls around and it is a memorable day, but for entirely the wrong reason. You see, that's because in the early morning of June 8th, Genesis Petrillo was rushed to the ER showing severe signs of alcohol poisoning. And even with the help from some amazing doctors on hand, they couldn't pinpoint her symptoms, and later that morning, she tragically passed away. It is a truly heartbreaking story. It is a tragedy, but it is not a crime. You're going to hear a lot more details about that night in question, and that's because the plaintiff in today's case is bringing a lawsuit against our client, Peony Estates. Today, they're alleging that Peony Estates was negligent in its handling of pesticides, which ultimately led to Ms. Petrillo's passing. However, throughout the entirety of today's trial, they won't even be able to tell you how much pesticide Ms. Petrillo consumed. And that's just the first missing piece in the plaintiff's case. Ladies and gentlemen, today the plaintiff has a burden. They have to prove their case by preponderance of the evidence. And that basically means more likely than not. That burden stays on their table during the entirety of today's trial, and it never moves to ours. However, the three elements that they have to prove is that Peony Estates failed to put sufficient restrictions in place to protect against the contamination of their wine, that they failed to store pesticides in a safe manner, and this is the important one, members of the jury, that as a result, the bottle of Caro wine was contaminated with unsafe levels of organophosphate pesticide. If they can't meet any of those three elements, they fail to reach their burden. And they're going to come up here in a few moments and they're going to paint you a story. But as you start to think about it, you start to realize more and more that that story has gaps. And then we're going to stand up and we're going to call three witnesses to highlight those gaps for you today. First, well, you're going to hear from Blair Osborne. He's one of the best event planners in the Rapid River Valley area, and he's been working closely with Peony Estates for years. He's going to tell you that during the 83 events that he's hosted at Peony, not one single person has complained about contaminated wine. That during his time walking around the premises, planning different types of events, he's never seen anything that's given him cause for concern. Then you're going to meet Dr. Cannon, a longtime toxicologist and medical consultant. Dr. Cannon is going to tell you much more about the night of the 7th. He's going to tell you that Genesis Petrillo showed up to the ER quite intoxicated. And he's going to clarify some important information about how pesticides work and how important dosage is. If there's one thing you remember during today's trial, let it be this, that the dosage makes the poison. And without the dosage, you can't have a poison. Finally, you're going to hear from Austin Lewis. She's the head winemaker at Peony Estates. And ladies and gentlemen, today she's going to teach you how to make some wine. She's going to start at the grape all the way through the bottle. She's going to tell you about the bottling process and all the safety implementations Peony Estates has in place to ensure that their wine is the safest it can be and the best quality that they can make. At the end of today's trial, the evidence will clearly show that it wasn't contaminated wine that caused Ms. Petrillo's death. That Peony Estates took precaution after precaution to ensure the safest quality of wine that they possibly could. And at the end of today's trial, when you consider all the questions that you have, all the missing pieces that the plaintiff fails to sew together, my co-counsel, Ms. Logan Colson, will stand before you here today and ask that you find Peony Estates not liable. Thank you, Your Honor.
Thank you, Mr. Kurup. I believe now time to start the plaintiff's case in chief. So if we may have whoever will be on behalf of the plaintiff, their witness, and one member of the defense team, you guys can join the video. All right, I see we have Ms. Johnson, we have Ms. Parsons, and Danny Francesio. All right, and we, as discussed during pretrial motions, the witness has already been sworn. So Ms. Johnson, you may begin whenever you're ready.
Good afternoon. Could you please introduce yourself to the court?
Sure. My name is Danny Francesio. I'm 39 years old, a diehard Patriots fan, and I own the best and largest winery estate in Midlands.
Can you go into further detail about the winery that you own?
Sure. It's called Rosie and Pedro's, which I named after my 2 rescue dogs. I've been in the wine game for the past 15 years after receiving my BS in biology and an MBA from Duke. So I basically turned my grapes into gold.
Mr. Francesio, how are you involved in today's case?
To put it simply, I know Harper Martini.
And what is your relationship like with Ms. Harper Martini?
Harper used to work for me. She was initially hired as a cellar hand, but was promoted after when my 2 other managers had to leave. That's also when I met her daughter, Casey, who I'm very fond of to this day. They were both like family to me before Harper went off to open her own winery. But business is business, so I never really held a grudge, kind of like when Tom Brady left us to sign with Tampa Bay this last spring.
So you said that Ms. Martini started with you as a cellar hand. What were her responsibilities like during that time?
One of Harper's responsibilities was making sure that the cellars were clean and making sure that they were clear of any pests. If she noticed any, she was to report to me so that we could seal off the barrels, move them, and then spray the pesticides.
How would you describe Ms. Martini as an employee?
At first, while working for me, she was great. But now I think most of the credit for her work goes to her managers, not to her.
And why do you say that?
Objection, Your Honor. Relevance.
Ms. Johnson, you care to respond?
Your Honor, we're simply setting foundation for Mr. Francasio's relationship and his opinion of Ms. Harper Martini.
May I respond, Your Honor?
Yes, you may.
Your Honor, we're talking about what's happening after Ms. Martini moved on from Rosie and Pedro's and has been working with her own winery. What she did several years ago back at Danny Francasio's winery is not relevant to the facts of today's case and trial, as we're focusing on what's been happening in the past couple years and not the past several years.
I think I'm going to overrule the objection for now, hear more just about the relationship and as it pertains to the work done. So, Ms. Johnson, I'm sorry, you may proceed with this line of questioning.
So again, Mr. Francasio, what makes you say that?
Well, just 2 years after opening up her own winery, Harper sent me a few concerning emails that caused me to worry.
And Mr. Francasio, if I were to show you these emails in court today, would you recognize them?
Yes.
Your Honor, permission for co-counsel to bring up Exhibit 14?
Yes, does Ms. Parsons, do you have any objection to this?
No, Your Honor.
All right, if you could pull that up, please.
Working on that. Sorry, it's not pulling up. Give me just another few seconds.
Your Honor, I actually already have Exhibit 14 pulled up, and I wouldn't mind sharing my screen for opposing counsel if that would be, if that would help them.
That would be fine by me. Has any objection, as long as it's the same exhibit?
No, very kind of you. Thank you. I apologize for the technical issue.
Your Honor, in our Exhibit 14, we do have Mr. Francasio's words blacked out because they are hearsay. So will that be objected to if they're not blacked out in a...
Your Honor, we can just have them constructively redacted.
Okay. Thank you. All right, we now have Exhibit 14. There it is.
Mr. Francasio, do you recognize this exhibit?
Yes, this was the second email, and well, the second email and my words have been redacted.
And would you describe these as a fair and accurate representation of the emails?
Yes.
Your Honor, the plaintiff offers Exhibit 14 into evidence.
Just real quick before we do that, which one is supposed to be blacked out? The email at the top?
The email at the bottom.
Is supposed to be blacked out?
No, the email at the top is supposed to be blacked out.
Okay, so you're offering this one that's at the bottom?
Yes.
And do we have any objection from defense counsel?
No, Your Honor.
All right, so admitted.
Now, you mentioned that these emails were concerning to you, Mr. Francasio. Why is that?
Well, if you look at the second and third line of Harper's email, she mentions that she can't get the pest out of her cellar and that it was starting to cause her to worry. That really concerned me because it seemed like she couldn't remember how to get the pest out of her cellar. I mean, she had done an amazing job while working for me, but I guess she kind of ended up being like a first-round draft bust who just couldn't cut it after college.
Your Honor, permission to take down this exhibit?
Yes, I've taken it, unless anyone else see it. All right, thank you.
So, Mr. Francasio, why did you respond to these emails?
I was worried that she would poison someone who consumed her wine. I was worried for the consumers and the people of Rapid River Valley, so I decided to take action.
And what kind of action did you take?
I contacted Lonnie Paris about a possible pesticide contamination at Peony Estates, since knowing how to handle pests is part of the fundamentals of making wine and operating a winery, kind of like knowing how to tackle correctly in football. But in this case, if she didn't do it right, someone could die.
Did Ms. Paris get back to you about your tip?
No, not at first, not until May of 2019, but a lot happened before then.
Could you tell us a little more about what happened between that time?
Harper's daughter, Casey, and her fiance, Genesis, actually approached me about having their wedding at Rosie and Pedro's. I was super excited. Like I said earlier, I was very fond of Casey and still am. But unfortunately, Harper forced them to move their wedding to Peony and sent me a dubious apology email in exchange.
Was this the last time you spoke with Ms. Martini?
No, it was not. After this email, she began leaving me a lot of voicemails regarding the wedding, Casey and Genesis's wedding. I'm not a therapist or a coach for that matter, but she really didn't seem to care. Honestly, I wasn't interested in how she was doing until that investigator that I talked about earlier, Lonnie Paris, contacted me in May of 2019.
What did Miss Paris contact you about?
She actually had followed up on my tip from a while back and wanted to know if I had any other information. I did not, but I paid attention to everything that Harper told me after that.
Mr. Francasio, what did Miss Harper say to you after that?
Harper emailed me saying that Peony had failed a health inspection. The inspector caught her storing pesticides and having a clogged up drain in the cellar, so she came to me for advice.
What was your response to her approach?
Well, I gave her the advice because I care about the consumers. I also had a soft spot for Casey, and I knew that her wedding was coming up in a few weeks. And if Harper didn't get the pest infestation under control, she would have to move the wedding or cancel it even.
What advice did you give her?
Well, I gave her the name of a product that we use to flush out the drains. And I also advised her to completely clean out the cellar and the warehouse. The fact that she was experiencing these issues again very concerned me.
Why did they concern you?
Well, I couldn't believe that she had forgotten all of her training while working for me. Granted, my previous managers had done an excellent job training and supervising Harper's work as they did with all of my employees, but Harper actually had done a very good job while working for me.
Mr. Francasio, what did Miss Martini do with your advice?
Objection,
I don't know.
Your Honor. May I be heard?
Yes. If
Speculation.
let's hear. If you want to elaborate a little bit on that, please.
Yes, Your Honor. Opposing counsel just asked Mr. Francasio what Ms. Martini did with his advice. However, as Mr. Francasio is not Ms. Martini, he has no way of knowing what she did with the advice and how she followed it.
Ms. Johnson, do you care to be heard?
I don't believe that this is speculation, Your Honor. I think that Mr. Francasio, Mr. Francasio will further go into the fact that he does not know about whether or not Ms. Martini took this advice. This is simply laying for foundation for the fact that Mr. Francasio has no idea whether or not Ms. Martini did or did not take the advice. It's foundation setting for the fact that Harper Martini very well could not have taken his advice. It's not speculation.
I think at this point, I'm going to sustain the objection. It doesn't. He can testify to the things that he personally knows and was able to see and witness. But right now, it does. I don't know if the foundation has been laid as to whether or not he does have that knowledge. You can try and get him to talk about what he might have known by seeing something. But at this point, I'm going to sustain the objection.
Mr. Francasio, do you know if she ever took your advice?
I do not, but I mean, knowing her and knowing that she had these issues for who knows how long, and after speaking with Genesis about some issues, she probably didn't.
What makes you say that?
Well, Genesis had approached me and asked me how one could anonymously report a health code violation because of something she had seen. I told her what I knew since it sounded like she was concerned about the public safety.
And what did Genesis ended up doing with that report?
I don't know, but that was the last time I spoke with her about something not concerning the wedding. I was actually planning on speaking to her after the wedding, but I unfortunately never got the chance.
No further questions, Your Honor.
All right. Thank you, Ms. Johnson. Ms. Parsons, do you have anything on cross-examination?
Yes, Your Honor.
All right, you may proceed.
Good afternoon, Mr. Francasio. Can you see and hear me all right?
Yes, I can. Good afternoon.
If that changes at any time, please let me know, okay?
Okay.
Okay, Mr. Francasio, I want to start by talking about your relationship with Harper Martini. Now, you run a very successful winery in Midlands, right?
Yes, I do.
And that winery is Rosie and Pedro's, right?
Yes, which I named after my 2 rescue dogs. They're schnauzers.
Now, a winery has a lot of moving pieces, right?
Yes, it does.
So you keep on average about 8 to 10 staff members, am I right?
Yeah, it differs from year to year, but I would say on average, yes.
So in 2012, you hired Harper Martini as one of those employees, right?
Yes, I did.
And you stated previously that she was a cellar hand, right?
Yes, that's what she was hired as.
And during her time, she worked to make sure that your cellar was clear and free of pests, right?
That was one of her responsibilities as a cellar hand. So yeah,
And during this time, Mr. Francasio, you said you were even impressed by Ms. Martini's work, right?
I was. She actually exceeded expectations, kind of like Tom Brady did with the Patriots back in the early 2000s. But yeah, they were pretty low expectations at first, since I hired her as a cellar hand, which was probably one of the most basic positions.
But Mr. Francasio, that's a yes to my question. You were impressed by the work she did, right?
Yes, I was.
In fact, you were so impressed that you even then promoted her in 2014, right?
Well, to clarify, I promoted her after my previous managers had to leave Midlands. But yes, I did promote her.
Yes, you did pick Ms. Martini, right?
I did.
And then a few years later, Ms. Martini comes to you and she tells you she's going to open her own winery, right?
Yes. I mean, it was actually less than a year later.
Right, but she comes to you in 2015 and she tells you she's going to open her own winery, right?
Yes, that's correct.
And you didn't take very kindly to this, did you?
No, I didn't.
In fact, you said you felt betrayed, right?
Right, because I considered her family at the time.
In fact, you were so upset that you told Ms. Martini you never wanted to see her again, right?
At the time, yes. I mean, it was an emotional outburst on my part.
Mr. Francasio, is that a yes to my question? You said you never wanted to see Ms. Martini again.
Yes.
Objection, Your Honor. Relevance?
Ms. Johnson, you want to elaborate a little bit, and then Ms. Parsons, you may be heard if you would like.
I just don't think that whether or not Mr. Francasio liked or wanted to see Harper Martini again is relevant to proving whether or not Peony Estates and Harper contaminated or handled their pesticides properly.
Your Honor, may I respond?
You may.
Your Honor, this is relevant because it goes to the witness's credibility. It goes towards their bias, which affects their testimony today in trial.
I think I tend to agree with Ms. Parsons. I'm going to overrule the objection. Ms. Parsons, you may proceed with your questioning.
Let's move on to what happened after Ms. Martini opened up Peony Estates. Now, between the time she left and the time you heard from her next, a year went by, right?
Yes, that is correct.
And she emailed you in 2016, right?
Yes.
And at this time, you were still mad at her, weren't you?
No, I wouldn't say that I was.
You mean you weren't fuming when you received the email and read the first few lines?
Well, I mean, if we're talking about the first email, which, I mean, I would have to point out exactly why I was angry, because there was a certain line in that email which did anger me. But
Right.
The reception of the email didn't anger me in any way.
But you were mad when you read the email. Is that a yes, Mr. Francasio?
Because of an unprofessional line that was stated by Harper, that angered me. But the email itself
I'm going to need a yes or a no.
was, okay, could you ask the question again?
That you were mad when you read the email.
Yes.
In fact, you were so mad that you didn't even respond to it the first time, did you?
Well, I had other business matters to attend to. The unprofessional line in the email did kind of put me off, but I had other matters to attend to.
Mr. Francasio, after Ms. Martini opened her winery, you saw a significant hit to your own winery sales, didn't you?
I did.
In fact, you even lost a portion of your own staff, didn't you?
Yes, I did.
You even had to take a 25% personal pay cut, right?
So I wouldn't have to lay anybody off. I care about my employees.
And the person you blamed for all of this was Harper Martini, right?
No, not exactly.
Mr. Francasio, you did not blame Ms. Martini for these instances?
Specifically, no. I would blame Peony Estates and Harper as competition in a business perspective, as the winery, as my sole competitor in Midlands. That was the reason why sales at first, when she opened, did go down, and why staff morale did go down, and why I did have to hire new employees. But Harper Martini specifically, in no way was the fact that.
Mr. Francasio, I just want to ask you one more time that you do not primarily blame Harper Martini and Peony Estates for your business troubles.
As my sole competitor in Midlands, yes, she was the primary, as you phrase it, the primary reason for my troubles.
Mr. Francasio, one last point I would like to clarify for the court. You've never actually stepped foot on Peony Estates, right?
No, I never have.
So you've never seen how they produce their wine?
No, I assume it was pretty close to what we do, since the wine process doesn't differ much in between wineries.
Mr. Francasio, can you please answer with a yes or no question? You've never seen how they produce their wine?
No, I've never seen how they produce their wine.
You've never seen even what sort of pesticide they use?
No.
You've never seen how they use their pesticide?
No.
You've never even seen how that pesticide is stored?
Well, Harper did send me some emails, which kind of alluded to the fact that she was having problems with that, especially the email concerning health inspections. She said that they caught her storing them incorrectly or something
Mr.
of the sort.
Francasio, I'm asking if you yourself have ever seen how Peony Estates have stored their pesticides.
No, I never have.
Thank you, Your Honor. I have no further questions.
All right, thank you, Ms. Parsons. Ms. Johnson, do you have anything on redirect you'd like to ask?
No, Your Honor.
All right, so I guess Mr. Francasio, you are free to go. You can obviously stay in the chat and watch the remainder of the trial, but you're under no obligation to do so. I guess now it will be time for any further witnesses that by the plaintiff. You're free to call your next witness.
Yes, Your Honor. The plaintiff calls Lonnie Paris to the stand.
All right, and whenever you guys are ready, you may begin your line of questioning.
Yes, Your Honor. Please introduce yourself to the court.
Hey, y'all. I'm Lonnie Paris.
Ms. Paris, what do you do for a living?
Well, I'm a journalist, but I also have a pretty successful blog on the side called Life in Paris. More recently, though, I have focused on getting back into investigative journalism.
And why is that?
I actually had a pretty intriguing story come my way. It started way back in 2016, but I've just recently been following up on it.
And what story is that, Ms. Paris?
Well, I got a tip about a winery called Peony Estates and that they were possibly mishandling pesticides around their wine. I didn't really follow up on this until July of 2018, though.
What made you change your mind in 2018?
At the time, I didn't have a better Life in Paris entry lined up, so I was looking through some of my old notes and I came across the Peony Estates tip again. I looked it up and I saw that they were situated right near a swamp, so I figured that they might have reason to use pesticide, but decided to go there myself just to see.
And did you go to Peony Estates?
I did, yes. I went in July of 2018 and I actually took a guided tour so that I could see more of the property. I learned that their wine only takes a year to produce, which was helpful later, but at the time I just wanted to get some more behind the scenes look at things, since businesses like these usually don't air their dirty laundry out where everyone can see them. So I headed into the employees only section, and that's where I got the real scoop.
What did you find out in the employees only section?
Well, I saw a lot of cans of pesticide just scattered.
Objection, Your Honor. Lack of foundation. May I be heard?
Yes, you may, Mr.
At this point, opposing counsel has not laid any foundation that Ms. Paris has any past experience or knowledge working with pesticides to say that she was able to identify cans of pesticides that were scattered merely is implausible right now, Your Honor, because they haven't laid the foundation for that. Ms. Paris hasn't worked in a winery. She hasn't worked with pesticides, at least according to her testimony thus far. And therefore, unless opposing counsel can lay that foundation, the testimony isn't admissible at this time, Your Honor.
If I may respond.
Yes, you may, Mr. Kanduri.
I believe that Ms. Paris does not need to lay any specific foundation to know that a can of pesticide is a can of pesticide. Clearly, she's not testifying as to what the pesticides were doing there or who placed them there. She simply stated that she saw those cans there scattered around. There is no particular foundation needed other than that she saw those cans, which has clearly been laid in this question.
May I reply on those grounds, Your Honor?
Briefly, yes, Mr. Krupp.
While I agree that her being able to see cans does qualify for her testimony, it's within her rationally based perception. My issue has to do with more the fact that opposing counsel hasn't laid any foundation that she knows what canisters of pesticide look like. And therefore, at this time, it's still inadmissible.
Your argument may be heard.
Yeah, briefly.
It has been laid that Ms. Paris has done research on this case previously before attending this particular case. Moreover, it does not require any expert knowledge or a specific foundation to know what a can of pesticide looks like, as most cans come with labels anyways.
I think based on the testimony that we've heard so far, we can safely assume that what Ms. Paris was witnessed was a can of pesticide. And as noted, she's not going to be saying, what is being done with that or anything about the chemical makeup of that, but she can at least testify to at least what she believed to be a can of pesticide. I apologize. So I will overrule that objection. And Mr. Kinder, you can continue with your line of questioning.
Yes, Your Honor.
Yes, Your Honor. Ms. Paris, could you tell us more about what you found in that wine cellar?
Yeah, like I was saying, I saw a lot of cans of pesticide labeled bug off all around the back room of the wine cellar. And I also did see a note written by a Peony Estates employee that I gained valuable information from.
Would you recognize a copy of that note if I were to show it to you in court today?
Yes, absolutely.
Your Honor, permission to display Exhibit 12.
Do we have any objection from defense counsel, Mr. Currup?
I currently don't have Exhibit 12 up. Is there any way they could display Exhibit 12 and then I can give an objection?
Yes.
Yes. Okay. We now have Exhibit 12 on the screen.
No objection, Your Honor.
Okay. Mr. Kanduri, you may continue.
Yes, Your Honor. Ms. Paris, do you recognize this exhibit?
I sure do, yes.
What is it?
Well, it's that note that I found in the back room that was written by Austin Lewis, the head winemaker.
And is it a fair and accurate representation?
It is, yes.
And have any alterations been made to it?
No, not that I'm aware of.
The plaintiff offers Exhibit 12 into evidence.
Do we have any objection from Mr. Currup?
Without objection, Your Honor.
All right. So entered. Mr. Kanduri, you may continue.
Yes, Your Honor. Ms. Paris, what did you learn from this note?
Well, I learned that Peony Estates was undergoing a pest infestation. And in the middle of that first paragraph there, it says attempts to ignore the issue have failed, which made me a little concerned because it sounded like it had been going on for at least a little and they just hadn't done anything about it. But then the note did go on to say that they'd be spraying pesticides later to try and get the situation under control.
Your Honor, permission to take down Exhibit 12.
Yes, you may take that down.
Ms. Paris, what did you do after you read the note?
Well, I left pretty quickly after because I was almost spotted. But after hearing about how they'd been ignoring a pest infestation, I definitely felt it was a story worth pursuing.
And what did you find out after you decided to pursue the story further?
Well, I did visit Peony Estates myself multiple times after, but in the meantime, I also wanted to familiarize myself with relevant health code statutes. That way, in case Peony Estates was breaking any violations or making any violations, I guess, I'd be able to tell what was going on. So while I was doing all this digging, I did have a bit of a light bulb moment.
And what was that light bulb moment?
Well, remember how I said that I had learned Peony Estates only sells wine that takes a year to produce? After seeing that note from Austin Lewis, it all dawned on me. If they were just now starting to spray pesticides, then their grapes wouldn't be affected until the ones were grown that would be made into their 2019 wine. I knew that this meant they could run into some issues with the Midlands Building Code statute 12100.
Now, you mentioned that you returned to Peony Estates again. When was this?
I became a bit of a regular there, to the point that the staff would see me and chat with me whenever I went. But my next big breakthrough came in May 9th, I think, May 8th or 9th of 2019.
And what was that breakthrough, Miss Paris?
Well, I was in the wine cellar Peony Estates again, looking for some clues, and they were in the middle of an inspection. So I noticed while I was there a couple things. One being that there was this bottle labeled Cara sitting all by itself on a shelf in the bottling area. And I also saw that all the pesticide cans I'd seen before had somehow disappeared. The real scoop came when I overheard that health inspector and Harper Martini talking about health code violations, though.
Did you have a chance to look at anything else at Peony Estates?
No, at that time, Austin Lewis actually saw me, so I decided to head out.
And was that the last time that you were there at Peony Estates?
No, the last time I was actually investigating the story was on June 7th, 2019, which was the night of this big wedding rehearsal. While I was there, I made a discovery that pointed to possible pesticide exposure in their wine cellar.
And what was that discovery, Miss Paris?
I noticed a can of pesticide spray laying right next to their bottling station. This was a huge red flag to me. I could barely believe my own
Objection,
eyes.
Your Honor. To this point, may I be heard?
Yes, you may.
While the witness is free to say what she saw, the fact that she's then testifying about how it was a red flag to her has no bearing or makes any fact of consequence more or less likely in today's case. The objection is to relevance to what Miss Paris's reaction was then to seeing a can of pesticide next to the winery area. In addition, they haven't laid any foundation that she's an expert, so we know that this testimony is not part of 702, so it can't be under expert testimony. So therefore, her opinion on the matter is irrelevant in today's trial, Your Honor.
Your Honor, if I may be heard.
Yes, you may.
I would like to know if counsel is making an objection as to either relevance or as to improper opinion testimony, or if you'd like me to address both.
May I respond, Your Honor?
Mr. Kenduri, if you could just address both matters.
Yes, Your Honor.
Yes.
Regarding the relevance objection, Ms. Paris is not testifying as to Ms. Paris is testifying as to what those pesticides made her think of. Now, because she reviewed Midlands Code 12100, she's well aware of it, as she said, the possible health code violations that could result. Her impression of the pesticides is key to understanding exactly what the proximity was. And her concern, if I may make an offer of proof.
Yes.
Her concern will parallel the same concern that Inspector O'Keefe will later testify to in today's case, and therefore is incredibly relevant. And as to the improper opinion testimony objection, we have laid foundation that Ms. Paris is very familiar with the Midlands 12100 code regarding pesticide storage, as well as with FDA regulations. Therefore, her being able to testify as to whether there could or could not be a possible violation is completely acceptable. She is not going beyond her bounds by saying that there is a violation.
Your Honor, may I respond on those grounds?
Yes.
Specifically the 702. The fact of the matter is she's not an expert, Your Honor. Like, they have not laid any 702 foundation that would allow her to be an expert. So her testifying on hypotheticals or her testifying to what information she has read is not within her purview as a lay witness, and therefore the testimony still isn't admissible, specifically under 702, Your Honor.
If I make a brief response.
No, I think what I'm going to do here is I agree with you, Mr. Kurup, that Ms. Paris does not qualify as an expert, and her testimony won't be given the weight that would be due an expert. However, I think she is allowed to testify that when she saw the pesticide to the other could qualify, or that it was a red flag to her. She's allowed to testify what she believed based on what she perceived. And so I'm going to allow the testimony to come in. But again, I will instruct the jury.
We get a limiting instruction to members of the jury that
that it should only be given the amount of weight as any lay witness, as she's not an expert in that field, and she's not been tendered as such. Mr. Kenduri, you can continue your questioning.
Yes, Your Honor. Ms. Paris, when you visited that wine cellar on May 8th, did you see anything else?
Yeah, so like I said, I saw that there was a pesticide or a can of pesticide spray laying right next to the bottling station, which again was a huge red flag to me. but I also did see that same bottle, or what I thought was the same bottle of Cara wine on the bottling shelf, and it hadn't looked like it had been moved from when I'd visited previously. And then a few moments later, my concern about them producing contaminated wine only got worse.
Why is that?
Well, I saw Harper pick up the bottle of Cara, and then I later saw Genesis later receive that bottle of Cara. Before I left, I really wanted to try and talk to Genesis, but it was super crowded and I didn't want to blow my cover since I wasn't technically invited to the wedding rehearsal. So I figured I'd go back and try again the next day to talk.
Did you get a chance to speak with Miss Petrillo the next day?
No. I heard that on the morning of June 9th, she was in a coma and she later passed away from pesticide poisoning.
Thank you, Your Honor. No further questions.
All right, thank you, Mr. Kenduri. Mr. Kurup, if you have any questions on cross-examination, you may begin whenever you're ready.
Yes, Your Honor. Good afternoon, Ms. Paris. Can you hear me all right?
Yes, I can.
All right, please let me know if that changes at any point. I want to quickly clarify some of the things you just mentioned on direct examination. You'd agree with me that you don't work for the health department, right?
No, I definitely do not.
You don't have any expert knowledge regarding pesticide use?
No, I never said I did.
But just to clarify, you don't know anything about pesticide storage?
Well, I did brush up on the Midlands Health Statute 12100, which went over pesticide usage and how it should be stored. But beyond what that document said, no, I don't have any expertise in that area.
You're not an expert in like pesticide storage, for example, right?
No. Like I said, the only thing I know about it is what I read in 12100.
You don't work at a winery?
No, I do not.
You've never, in fact, worked at a vineyard, have you?
No, can't say I have.
Now, I want to talk about that first tip that you got. You got a tip in 2016, right?
Yes, I did.
And that was from Danny Francasio, correct?
It was, yes.
He's the owner of Rosie and Pedro Winery, right?
Yeah, he is.
Now, you conducted a web search to see whether or not anyone had gotten sick from the wine from Peony Estates at that time, right?
Yes, I did.
And that web search turned up nothing, right?
Correct. That's true.
So you set the story aside.
Yeah, at the time, I usually would have done some more investigating, but I did have a huge other story on my plate, so I decided to set the Peony Estates tip to the side.
But then in 2018, you were let go as an investigative reporter for BNN, correct?
Yes, due to some budgetary issues, I did have to be let go.
And then you came across your notes on the Francasio tip. Is that right?
I did, yes. I was looking through all my notes, but that one stood out to me at the time.
And at the time, you were looking for something that was going to revitalize your journalism career, right?
Yes, it's what I love to do, so I wanted to get back on the board, I guess.
And that's why you decided to investigate further, right?
Well, yes, but any story I would have investigated further. It just so happened that Peony Estates was the one that caught my eye at the time.
And so right after that, you were actually approached by Landon Green, right?
I was, yes.
Landon Green is the editor-in-chief of TBD magazine, isn't that right?
He is.
And he offered you a job, right, Ms. Paris?
He did, yes, based on how my story that I happened to be working on at the time went.
And that was the same job that you had before BNN as an investigative reporter, right?
Yes, it was the same job title, different company.
But you actually weren't offered that job right away, were you?
I was not, no. He wanted to make sure that my journalism skills were good, so he wanted to see how the story I was currently working on progressed.
Exactly. He told you that he wanted to see what else you could extract from that story, right?
Yes, that's exactly what the field of journalism really is.
And so then you opened a second wave of investigation into Peony Estates, right?
I did, yes. It was the most recent tip that I'd looked into, so I just went back to it.
But that still wasn't enough to secure your new job, was it?
No, he still wanted to see if I could do better. He wanted to push me to my limits, I guess.
So you needed to get more listeners?
Well, yes, that's usually why journalists write pieces, so they can inform the public.
You needed to dig deeper, right?
Yes, like I said, businesses don't air their dirty laundry out where everyone can see it. So jobs like mine do take some further investigating.
Exactly. You then went to Peony Estates. You started looking around, right?
Yes, I did.
Now I want to talk about one thing you mentioned on direct examination. You mentioned you saw some cans of pesticides in 2018, right? When you were there?
Yes. Can you specify the date? I'm sorry. I was there quite a few times.
During the July 18th trip to 2018.
Yes, that sounds right.
And you'd agree with me that those cans, they weren't open, right?
Not that I could tell, no.
They were to be used at a later date, right?
Oh, well, I have no idea.
You didn't hear that they were to be used at a later date?
Well, I might have overheard it, but I don't know if they ever actually were.
So all you can say at that time is you just saw a closed canister next to some closed casks of wine, right?
Yes, but in my opinion, that doesn't really make it any better. At the end of the day, pesticides are still in the wine supplying area.
Ms. Paris, I just need a yes or no, not your opinion. At that time, all you could see was a closed cask of pesticide near a closed container of wine, right?
Sure.
Thank you, Your Honor. At this point, I have no further questions.
All right. Thank you, Mr. Kurup. Mr. Kanduri, do you have any redirect for Ms. Paris?
No redirect, Your Honor. I asked that Ms. Paris be allowed to step down.
Yes. Thank you, Ms. Paris. Appreciate your testimony. You're free to go. Obviously, you can stay in the chat and watch the remainder of the trial if you want to do so. Now, I believe we have one more witness on behalf of the plaintiffs. Is that correct?
Yes, Your Honor.
Yes.
Would like-
Okay. Yes. You may go.
Thank you. We'd like to call Riley Adkins O'Keefe to the stand.
Yes, thank you. And you may begin your testimony or your line of questioning whenever you're ready. Thank you, Ms. Skura.
Good day. Would you please introduce yourself to the court?
Absolutely. Good afternoon. My name is Inspector Riley Adkins O'Keefe.
And what is it that you do for a living, Inspector?
I am the Senior Health and Environmental Safety Inspector for Rapid River County. And I am basically your typical health inspector that goes around making sure everybody's up to criteria.
And what kind of background do you have to hold such a position?
I am certified as a health and environmental safety inspector by the FDA, and I've worked for the DHES for 10 years.
And do you have experience with inspecting wineries in particular?
Yeah, absolutely. I've inspected over 170 wineries on behalf of the FDA in my career.
So what is your involvement in today's case?
I was the senior inspector that was dispatched to Peonia Estates and inspected them for a total of 3 times.
And what methods did you utilize to evaluate the winery?
On behalf of my conclusionary basis, I use something called an FFIR compliance method. It's a food facility inspection that is also partnered with a chart that lets you look over criteria put forth by the FDA and whether they're meet up to requirements.
And this chart, can you tell us what it details, please?
Yeah, absolutely. The chart details, it looks over criteria such as storaging, safety, how they operate. And there's 4 levels. There's in compliance, out of compliance, not applicable, or not observed. So when I go over my inspections, I relay the chart and look over the information.
And is this compliance method that you use standard in the industry?
Absolutely. I use it and many other inspectors do as well.
So you mentioned that you conducted 3 inspections at Peonia Estates. Can you please describe the first one?
Yeah, of course. It was my first inspection at Peonia State. I made sure to apply my FFIR compliance method and look over the grounds and inspect the whole facility to make sure they're keeping customers safe.
Mm-hmm. And the results of that first inspection were what, please?
The results of the first inspection was that they were out of compliance on the chart. On 27 specifically was their storage and usage of pesticides. It was stored much too close to the kitchen and to food or drink.
And was that considered a violation?
It was a violation. Pesticide is a poison, so it can be lethal if it contaminates. However, while letting Harper Martini know about it, Harper Martini ensured it was a mistake and brought it to a better storage facility.
How did the conversation go with Harper Martini as to this violation?
Once Harper Martini had moved the pesticide to the proper storage facility, and I agreed where it had been put, I approved of it and took away the violation and said they can operate as normal. However, I would be back in the future for future health inspections.
And you went for a second inspection, correct?
That is correct. The FDA got from an anonymous source a letter saying that Peonia Estates was using an above average amount of pesticide. and it was sent down to the DHES since we are under the FDA, and the DHES sent myself to inspect and investigate.
So how did that second inspection begin?
Upon arrival, I introduced myself to Harper Martini and said I was there for another inspection. And upon arriving and wanting to look at the grounds again, I noticed Harper Martini to be very nervous around me, avoiding eye contact and asking me to start somewhere else than where I wanted to start.
And after that conversation, what happened with the inspection?
Harper Martini reluctantly agreed to take me to the wine cellar first. That's what I wanted to inspect because of the letter, of course. I was brought to the wine cellar, and upon being there, I discovered pests near the wine. When you've been doing this as long as I have, I noticed that they'd been there for several weeks, and I wanted to test the wine. So I took the wine at random, 20% of the wine, and sent it to the lab to get results.
And did you speak with any other employees while you were there?
Yes, because of the previous usage of the storage of pesticides and now seeing dead pests, I asked Harper Martini if I can speak to the employees alone to interview them.
And with which employee did you speak?
Well, at first I spoke to Austin Lewis, and Austin Lewis told me that indeed the employees do put pesticide closer than what Harper Martini had previously told me because of the inconvenience of the storage.
So after learning where the pesticides were really being stored and this inconvenience, what was your next step?
I then strongly recommended to Austin Lewis and Harper Martini to make a new storage location that was convenient for the employees. I want to reiterate that pesticide is a poison and it can be lethal in high dosages. And if you have a storage area that's inconvenient and employees aren't putting it where it's supposed to be, it can lead to harm to the consumers.
And did you follow up with yet another inspection?
Yes, of course. I followed up with an unscheduled inspection due to the previous inspections. I wanted to make sure they're up to date with the criteria and they're functioning correctly and heeding my advice.
And when you got to Peony Estates for the third inspection, what did you find?
I conducted it the same exact way. I started in the wine cellar. I found no pest and everything was up to date and I didn't need to get the lab results of the wine cellar. Then I moved around inspecting the grounds and later finding 3 health code violations during my third inspection.
And did you document those violations?
Yes, absolutely. It was in the bottling facility specifically. There were 4 health code violations on my third inspection. The first being that pesticides were stored right near the bottling facility. The second was that the drainage system was not properly working, meaning that poison, aka pesticide, was not properly draining. The third was after interviewing employees, they didn't understand the importance of keeping pesticide away from food or drink. And the fourth was a bottle of Cara wine sitting right next to pesticides.
So what did you do with all this information once you compiled it?
I let Harper Martini and the employees know that these were 4 health code violations and they would be operating on a probationary basis. And they had 40 days to fix everything.
Nothing further, Your Honor.
All right, thank you, Ms. Skura. Who do we have on behalf of the defense for cross-examination?
Your Honor, I will be cross-examining the witness.
All right, thank you, Ms. Colson. You may begin whenever you're ready.
Good afternoon, Mr. O'Keefe. Before I begin, I just want to make sure you can hear and see me clearly.
Yes, I can hear you loud and clear. Thank you.
Please let me know if that changes at any point.
Absolutely. Same goes to you. Thank you.
Now, you've told us a lot about the multiple visits that you took to Peony Estates, so I want to break those down a little bit.
Absolutely, ma'am.
We'll start with your first visit in 2015.
Of course.
Now, at this visit, you found that Peony Estates did use pesticides in their facility, right?
That is correct, and it was fully within their right. They're right on a swamp, so, I mean, of course they would use pesticides. There's a lot of bugs.
You also found the amount they use is within the acceptable range.
It was above average, but it was legal.
Is that a yes, that it was within the acceptable range?
Yes, ma'am. It was within the legal limit.
Then the next time you visited was in July of 2018.
For my second inspection, ma'am, correct?
And this was brought on by an anonymous tip?
That is correct, ma'am.
Now, you asked Harper about how she dealt with cellar pests during this visit, didn't you?
That is correct, and the way she told me about it seemed legit.
Now, despite this, you still took samples of the wine while you were there, right?
Well, of course, you want to make sure your consumers are going to be okay. So I took samples of 20% of the wine, and all the lab results came back good.
And just to be clear though, the lab results didn't show 0 contaminants, right?
It showed the same level, I believe, for the lab results, and that no further action was required.
So it showed safe levels of the isophenous pesticide in the wine.
For the wine that I did take samples of, again, it was only 20%. It did come back safe. That is correct.
Now, you never felt a need to test the wine when you visited in 2019. Is that right?
Of course, there was no pest cited, and I deemed that I wouldn't need to take more lab results.
So I'd like to discuss more about your pesticide storage, what you found about pesticide storage, Mr. O'Keefe.
For which inspection, ma'am?
Well, let's start with 2015.
Okay.
So you told Peony Estates to change where they stored their pesticides when you were there?
That is correct. It seemed inconvenient to me and my expertise. And upon talking to Austin Lewis, it was inconvenient for the employees as well.
But you still approved that they were allowed to continue bottling and making wine after this visit.
That's correct. After Harper Martini moved them to a good location, I agreed that if they kept it there, it would be acceptable.
Now, in 2018, they changed where they stored their pesticides.
That is correct. They had a new storage location. The previous one was all decorations and such. However, I did find pesticides in other places.
Well, let's talk about where they were storing them, though, because they were storing them in a new building during this visit, right?
Yes, that is correct. It was a whole new building.
And this building was located more than 50 feet away from the cellar.
It was in a convenient location. That is correct. The original storage facility, yes.
Now, you also returned on May 8th of 2019.
For my third inspection, ma'am, that is correct.
You asked to see the storage facilities again.
Absolutely, for the unscheduled inspection.
And they'd constructed yet another new storage shed, just like you asked.
Yes, they did heed my advice. My problem wasn't with the storage. They did great on the new storage. It was they didn't keep all the pesticide in there.
So they did create another new storage shed, just like you asked them to.
The storage was perfect, ma'am, but not the use of their pesticides.
But you still approved them to stay open after this visit on May 8th, 2019, didn't you?
According to the law, yes, on a probationary basis. I would come back within 40 days to make sure they heed the inspection. But that is correct. They could operate on a probationary basis.
Thank you. I have no further questions for this witness, Your Honor.
All right. Thank you, Ms. Colson. Ms. Skura, do you have anything on redirect?
I do not, Your Honor.
I'm sorry, do you say you do not?
I do not, no. Thank you.
Okay. Thank you. I guess the witness, you are free to go. Thank you, sir. Obviously, if you want to stay in the chat, you can watch the remainder of the trial. You're free to do that. I think, do we have any more witnesses on behalf of the plaintiff?
We do not, Your Honor.
Okay, so I guess that will constitute the plaintiff's case in chief. I believe now we have a 5-minute recess, and then we will resume with the defendant's case in chief in just a couple minutes.
Yes,
All right.
Your Honor.
Thank you, everybody. I'll see you in just a few minutes. Thanks.
All right, everybody. It's been, I guess, just about 5 minutes. If we could have the defense counsel and plaintiff counsel who will be directing and cross-examining the first witness. All right, I see we have Mr. Curup present. No, okay, we also have Ms. Johnson. And if we have whoever your first witness will be, Mr. Curup, whoever's from the defense. Yes, okay, we have Mr. Blair Osborne present as well. I guess, Mr. Curup, you may begin whenever you are ready. Thank you.
Yes, Your Honor. Before we begin, can you hear me all right?
Yes, thank you.
Mr. Osborne, can you please introduce yourself to the members of the jury?
Hello, my name is Mr. Blair Osborne.
What do you do for a living?
Well, I do a lot, but of course that comes with the job. I'm a CEO, CFO, and pretty much everything else that has to do with Bliss by Blair events.
For those of us who don't know, what is Bliss by Blair Events?
Well, we're an event planning service. We do weddings, corporate events, things like that. In fact, I like to bring this up a lot, but a magazine actually coined us as the best event planning service in the Rapid River Valley area.
Mr. Osborne, being in the Rapid River Valley area, did you ever meet Harper Martini?
Yes, I did. It was 2015 and my business was just starting out and I was kind of struggling. I was double booking events a lot was my main issue. One day I had the same venue booked and two people and neither wanted to cancel. So I started calling around and trying to find a venue that would be open. And eventually Harper Martini picked up and said that Peony Estates was available.
Did you host an event there?
Yes, I did.
How'd that event go, Mr. Osborne?
Well, honestly, the event went incredible. I mean, it exceeded all my expectations. The place looked great. The wine was great. I mean, it was just a huge success.
After that event, did you continue to work with Peony Estates?
Yes, I did. I continued to plan events there at Peony. I've hosted 61 weddings, 12 birthday parties, 9 corporate luncheons, and I've even had to do a funeral wake at Peony.
Can you tell us a bit about the event planning process, Mr. Osborne?
Sure, of course. There's a lot of work that goes into it, and it really isn't for everyone. I'll often spend hours making sure that the venue is up to par. I like talking to and working with the staff to make sure that everything's going according to plan.
So have you spent a lot of time at Peony?
Yes, I have. Having planned over 83 events, I've also been there for pre-event meetings and just venue walkthroughs.
And during all that time you spent there, have you ever seen anything that gave you cause for concern?
No, of course not. I wouldn't have continued business there, frankly, if I saw something even mildly concerning. Being there so much, I've known the place well, and they put themselves to high standards.
At your events, do you usually serve wine from Peony Estates?
Yeah, so it's normally a combination of catering and things like that. And depending on the event, I will often use Harper's wine.
And during all this time, did you ever get any complaints from people that had gotten ill from the wine?
No, never. Like I said before, I frankly wouldn't have continued business if people were getting sick from the wine.
During your time working at Peony, do you ever see pesticides stored near wine?
No, I have not.
Did you ever see a bottle that was labeled bug off next to some wine?
No, I haven't seen that either.
Objection, Your Honor. Character evidence.
I'm sorry, could you elaborate a little bit, Ms. Johnson?
Opposing counsel is using the fact that Mr. Osborne didn't see bug off anywhere near the wine, but that doesn't necessarily mean that it never happened. It couldn't have happened in the future. Just because it hadn't happened in his sight doesn't mean it could have.
May I respond on those grounds, Your Honor?
Yes, Mr. Curup.
So character evidence requires that there's a character trait to be present. Traits like anger or friendliness, for example, are common examples. The fact that Mr. Osborne, while working at Peony, especially for a negligence charge, didn't see any bottles of pesticides stored near wine, there's no character trait there, Your Honor. Therefore, it can't be character evidence.
I think I agree with Mr. Curup. I will overrule the objection, allow that to come in, and we will instruct the jury to give that the appropriate weight that it is due, given that he's not talking specifically about the day in question, but mostly just his experience during his time working there.
Yes, Your Honor. Now, Mr. Osborne, I want to talk about the night of July 7th. Where were you that night?
I was actually at Peony. I had been hired by Harper to plan Casey and Genesis's rehearsal dinner and therefore the wedding.
Did you spend time working with them to plan out the event?
Yes, I spent time with a lot of people, but specifically those three.
And how was that process?
Well, I only had a few months to spend working with those three. Wedding planning can often be very stressful. Tears are shed. People say things that they later regret. It can get kind of messy, but we always figure it out in the end.
During that time, did Miss Martini ever mention anything about pesticides?
Actually, she has. It was while we were talking about table placement. She said something about not wasting time training employees and to not move the pesticides from where they were.
Do you have any idea if she followed through on her claims?
No, I don't know if she followed through with what she had said.
No further questions, Your Honor.
All right, thank you, Mr. Curup. Ms. Johnson, if you have anything on cross-examination, you may begin whenever you're ready.
Mr. Osborne, you've worked with the defendant since 2015, right?
Yes, I have. I've planned. Our businesses have formed a partnership together. We've been planning a lot of events there.
And you've hosted 83 events at Peony Estates, right?
Yes, I have over the years.
Throughout this time, you've developed a solid relationship with the defendant, right?
Yeah, I would say that we have a rapport.
You would consider this relationship to be more than just professional, right?
Mm-hmm. Yes.
You would go as far to say that the defendant felt like family to you, correct?
Yes. Yes, she did feel like family.
Objection, Your Honor, to improper characterization of the evidence. May I be heard on those grounds?
You may be heard.
So opposing counsel saying the defendant, in this case, the defendant is Peony Estates. I believe opposing counsel is referring to Miss Martini and the relationship Miss Martini formed with Mr. Osborne. Characterizing Miss Martini, I'm sorry, there was a little bit of feedback. Characterizing Miss Martini as the defendant is improper characterization in today's trial, and therefore we merely ask this line of questioning be adapted to reflect the actual question opposing counsel is trying to convey in today's trial, Your Honor.
Ms. Johnson, you care to be heard?
No, it's okay.
Okay, so allowed, sustained, and we'll jury to reflect or to believe or hear that evidence as the defendant being obviously the estate and not Miss Martini.
Mr. Osborne, you would consider your relationship with Miss Martini to be more than professional, correct?
Yes, I would.
Objection, Your Honor, to relevance at this point. May I be heard?
You may.
Since opposing counsel is now talking about the relationship with Miss Martini, we're here to discuss a negligence charge regarding the entirety of Peony Estates. This line of questioning doesn't make any fact of consequence as to how Peony Estates stored their pesticides, how they deal with their wine, how they bottle their wine, more or less likely, and therefore the line of questioning is irrelevant at this time, Your Honor, unless opposing counsel can lay that foundation that makes it relevant.
Ms. Johnson, your response? Yes.
Miss Martini has been established as an agent of Peony Estates, and Mr. Osborne's relationship with Miss Martini is important. It shows bias, and relationship bias is always important and relevant.
Yes, thank you. I agree with Ms. Johnson. I'm going to overrule that objection. Ms. Johnson, you may continue your cross-examination.
Yes, Your Honor.
Mr. Osborne, Miss Martini asked you to Miss Martini hired you to plan her kid's wedding, correct?
Yes, she did.
And she asked you to be silent about your involvement in the wedding, right?
Yes, she did.
This was because Casey Soto didn't know you had been hired, correct?
That is correct.
You'd say that this request made you uncomfortable, wouldn't you?
Yes, it did make me a little uncomfortable.
But you agreed to remain discreet about your role, right?
Yes, I did.
Miss Martini offered you compensation for your quietness, correct?
Yes.
In fact, she offered you a 15% higher rate than normal. Am I correct?
Yes, she did.
Would you agree that this compensation influenced your compliance with her request?
I stayed discreet and I took the 15% increase, so yes.
I'd like to direct your attention to the night of June 7th, 2019. You witnessed Genesis receive the bottle of Cara wine, correct?
I saw that Genesis received a bottle of wine. I couldn't make it out. I was roughly 40 feet away. I was focused on a lot of other things, but I did see it from that distance.
You hadn't seen this bottle before it was presented in that dinner, correct?
No, I did not.
So you can't attest to whether this bottle was handled safely before it was presented to Miss Petrillo, right?
No, I can't.
Moving on after the rehearsal dinner, you encountered Genesis around midnight, right?
Yes, I did.
And it was apparent to you that Genesis had been drinking.
Yes, she had been drinking that night.
You'd agree that you weren't worried about the amount that she was drinking, right?
No, I don't think I was worried about the
Objection,
amount.
Your Honor, to relevance at this point. May I be heard?
Yes, you may.
We're here for a negligence charge, and opposing counsel is asking Mr. Osborne whether he was worried about how much Miss Petrillo had been drinking the night before. That's clearly irrelevant in today's case, Your Honor, and therefore this testimony should be stricken.
Ms. Johnson, do you have anything in response?
Your Honor, we're laying foundation for the fact that Mr. Osborne did bear witness to Miss Petrillo's state of mind, and he did say that she was she had been drinking, but he can attest that she was all right, and that the wine that she had been drinking or whatever she had been drinking did not have a dangerous effect or hadn't had a dangerous effect on her. It was important because this was the night that's in question, and Ms. Petrillo's state is in question.
May I respond on those grounds, Your Honor?
Yes, you may.
So we're still here, Your Honor, for a negligence charge, and the fact of the matter is opposing counsel hasn't laid the foundation that would allow Mr. Osborne's testimony to become relevant. We have no objection with the fact that he saw her drinking. He saw her being presented with a bottle of wine. But whether or not he himself was concerned about the amount that she had been drinking has no relevance, especially because he doesn't have any background or expert knowledge in toxicology, in alcohol awareness or alcoholism in general. He doesn't have a bearing as to whether or not his opinion matters in that regard, Your Honor. Therefore, it's still irrelevant.
I understand where you're coming from, Mr. Currup, but I think given, the line of work that Mr. Osborne is in, I think he can at least testify as to what and whether or not he thought that was more or less than an average person, something that might cause him concern. It's not necessarily the most relevant thing. I agree, but I think it's relevant enough that it should be allowed into evidence at this point.
Yes, Your Honor.
Johnson may continue.
Just to clarify once more that, Mr. Osborne, you were not concerned about Genesis Petrillo's alcohol level that night, or were you?
No, I was not concerned.
No further questions, Your Honor.
All right. Thank you, Ms. Johnson. Mr. Currup, do you have anything on redirect?
There's no redirect at this time, Your Honor. We merely ask that I merely ask that my witness be allowed to step down from the stand.
Yes, thank you for your testimony, Mr. Osborne. You are free to go. Of course, if you choose to, you may stay in the chat and watch the remainder of the trial. I believe, do we have any more witnesses on behalf of the defense?
Yes, Your Honor. The defense calls Dr. Cannon.
Yes, okay, and I see we have Mr. Kanduri here. Yes, all right. Ms. Colson, you may begin whenever you are ready.
Sure. My mistake, Ron. I accidentally clicked the video. I'm not the crossing attorney.
Okay, we have Ms. Colson. I see Dr. Cannon is present, and do we have somebody on behalf of the plaintiff? Okay, Ms. Skura, thank you.
Yes, Your Honor.
Yes, Ms. Colson, you may begin whenever you are ready.
If I may have just one to pull up the documents I'll be using.
Yes, you may.
Okay. Good afternoon. Could you introduce yourself to the members of the jury?
My name is Dr. Reynold Cannon.
What do you do for a living, Dr. Cannon?
I'm a medical doctor with expertise in toxicology and pharmacology. Currently, I'm an associate consultant for Gardner Consulting Incorporated.
Where did you receive your degrees?
Well, I got my BS from The Ohio State University, and then I got my MD from Harvard Medical School with an emphasis in toxicology.
Now, do you have any other practical medical experience you'd like to share with us?
Oh, of course. I was chief toxicologist over at Massachusetts General Hospital in Boston. I left that job to become a professor at Midlands Medical School. I then left academia for my current profession.
Have you ever testified in a civil case before?
Oh, absolutely. I've testified in over 35 legal cases, and of those, 30 of them were for civil cases.
Now, Dr. Cannon, what materials did you review in preparation for today's trial?
Well, as per usual in my field, I was only able to review documents. I reviewed some lab tests that were done, a death certificate of Genesis Petrillo, an alcohol impairment chart that was provided by the treating physician of the case, the report of the treating physician that met Genesis at the emergency room and treated her, and then the affidavit of a key eyewitness in the case.
Dr. Cannon, why didn't you examine Miss Petrillo's body?
Unfortunately, Miss Petrillo's body was already cremated by the time I was hired on for the case. This was hardly a problem though, because it's usual in my field to not really have access to the body as is.
Did you still have enough facts to come to your conclusions in today's case?
Oh, of course. I had enough facts to make my conclusions today.
Now, how do you normally go about evaluating medical documents in cases like this one?
Well, my colleagues and I perform what's known as a differential diagnosis or differential analysis. Essentially, we take the facts that we've observed and pair our expertise and experience in order to come up with other possible causes of death and see if we can provide a definitive cause for someone's passing. Think of it as a second medical diagnosis, kind of like what the treating physician did, except this time I don't have the pressure of time and I have the benefit of hindsight.
Did you reliably apply this analysis to this case?
Oh, of course, as always.
At this point, I'd like to move over to discussing the details of this case now. Dr. Cannon, you're a toxicologist, so how do you determine cause of death in cases involving poisoning?
Well, with poison, the key is dosage. There are two things that we really need to know. The first is that the dosage of the potential poison that causes death, generally speaking. Then we need to compare that number to how much potential poison that the victim consumed.
Then why is dosage so important when talking about poison?
Well, dosage isn't just important for conventional poisons that we like to think of from movies. It's important in every aspect of our life. If you have too much of anything, it could kill you. Take dihydrogen monoxide, for example. Too much dihydrogen monoxide can cause muscle spasms, nausea, and if you really have too much, it can cause death.
I'm sorry, was that an objection from you, Ms. Garrett?
Yes, it was, Your Honor. I object to this line of questioning and the subsequent answers under Rule 702. The methods that the doctor has described has really not met the prongs of 702.
Could you be a little bit more specific as to what methods you're talking about?
Well, everything in Dr. Cannon's testimony thus far has addressed his opinion and the opinions of his colleagues, which admittedly are learned opinions, but he has not described specifically scientific and technical methods that he applied in the case, other than just reviewing documents. So I would cite 702A.
Your Honor, if I may respond, Dr. Cannon specifically told us about how he used a certain analysis that is very common in his field to review all of the medical documents in this case. He also told you that he reliably applied this analysis in this case. Therefore, he has met that prong in 702 and is free to testify as to his conclusions. Furthermore, Dr. Cannon hasn't actually come to any conclusions thus far in his testimony.
Okay, so I will say I did have a little bit of technical difficulty for a minute during his testimony. It was right around when I think that would have come up. So I was out for a minute as I was switching over to my phone from my computer. But as an officer of the court, Ms. Colson, obviously you are, gotta be honest and truthful with the court. And I can't imagine you saying that he would have, or misrepresenting any testimony he might have given during that minute or so while I was out. And I believe, given what I had heard prior to my absence from the testimony, I think that the doctor may actually testify to this. So I'm going to overrule the objection.
Your Honor, may I issue a new objection?
Sure.
I would like to object on the basis of relevance in Dr. Cannon's testimony with respect to dihydrogen monoxide. Dihydrogen monoxide is water. It is not relevant in this case.
If I may respond on those grounds.
Yes, you may.
Dr. Cannon was just explaining to us the importance of dosage when considering poison. Now, this case is about organophosphate pesticide poisoning. Dr. Cannon was using this example of dihydrogen monoxide to show the jury that not everything that seems like it would be poison is poison unless it's at a certain dose. See, Dr. Cannon was just going to explain that at certain levels, dihydrogen monoxide can cause death. Now, that's just water. So he is giving the jury an example to show how not everything is poisonous unless it's at the right dosage. Therefore, this testimony is very relevant to today's case and is very admissible.
Your Honor,
I agree with Ms. Colson. I'm going to say that this testimony is relevant, and I'm going to overrule that objection as well. Ms. Colson, you may continue with your questioning.
Dr. Cannon, can you continue telling us about dihydrogen monoxide?
Of course. Like I was saying, any substance, if consumed too much, can cause death. Dihydrogen monoxide can cause muscle spasms, nausea, and eventually death. The attorney stole my thunder, but dihydrogen monoxide is water. It's just like I would tell my students at Midlands Medical School. The dose makes the poison.
Now, how does dosage specifically apply to this case?
Well, the potential poison in this case is isofenfos, essentially an organophosphate pesticide. Key word for this case being pesticide. Now, the two things we need to know is how much isofenfos is required to cause death normally, and how much did Genesis Petrillo consume before she passed.
Dr. Cannon, do you know what the lethal dosage of isofenfos pesticide is?
Unfortunately, I don't. I don't provide any peer-reviewed studies to show what this dosage is. And in the treating physician, in all the information that he provided for this case and that I reviewed, he doesn't provide any of this information either.
Then can you tell us the exact amount of isofenfos pesticide that Genesis actually consumed on the night of June 7th?
Unfortunately, I can't. The tests that the treating physician did were to analyze levels of acetylcholinesterase, essentially an enzyme that can be found in the body. This enzyme, if it's found in low amounts, as it was in Petrillo's case, can show that there was presence of isofenfos in the blood, in the body. But it doesn't tell us how much, and that's the problem.
Dr. Cannon, if you can't tell us the lethal dosage of isofenfos, or how much isofenfos Genesis Petrillo had in her body and actually consumed, what conclusions can you make in this case?
Well, you hit the nail on the head. I can't make any conclusions on this case about the definitive cause of death. That's the real problem, considering that we just don't have enough facts and data here to make any definitive conclusions.
Then I'd like to talk more about the actual bottle of Carl wine that Genesis drank from. If I were to show you the analytical report done by Meta Laboratories on this bottle, would you recognize it?
Of course. I reviewed it for today's case.
Permission to share my screen, Your Honor?
Yes, you may.
Now, is this that report?
Yes, it is.
The defense would like it to bring it to Your Honor's attention that Exhibit 10 has been stipulated as pre-admitted in today's case.
Yes. Okay. Thank you for that reminder. This exhibit shall be admitted into evidence as per the stipulation.
Now, Dr. Cannon, can you explain to the jury what this is?
Essentially, this is a lab test that was done to analyze the substances found in a wine bottle that was found in the dumpster at Peony Estates.
Now, we'll be specifically discussing the isofenfos section that I've highlighted here, but So directing your attention to this highlighted section, could you explain to the jury what the reporting limit is, or RL in this row, means in this report?
Of course, the reporting limit is an objective concentration that is set by the FDA. Essentially, for food and drink safety concerns, the FDA sets a concentration that they deem to be safe, as to see of how much of a concentration is allowed of any substance in food or drink before it's considered to be unsafe.
Now, is this reporting limit a dosage for isofenfos?
In medical terms, absolutely not. The FDA and medical doctors, when we're making our diagnoses, they're kind of separate. So in medical terms, as far as weight for making my conclusions today, this number had little to no impact.
So looking back now at the row labeled isofenfos, we can see the bottle had 91 micrograms of isofenfos. What exactly does this tell us about the amount that Genesis consumed?
Unfortunately, it doesn't really tell us anything. The bottle was found in a dumpster long after Genesis drank the contents of the wine bottle. We don't know when the wine bottle was contaminated with isofenfos. It could have been either before or after.
Since we can't know for sure if the cause of Petrillo's death was actually isofenfos pesticide poisoning, are there any other explanations you can give us?
The treating physician primarily offers the idea, initially offered the idea of alcohol poisoning as being the reason. However, he ultimately ruled it out because Petrillo's blood alcohol concentration, BAC, was only 0.1% at the hospital. However, it's likely that Petrillo's BAC was much higher when she was at Peony Estates.
Objection, Your Honor.
Yes, if you'd like to be heard, Ms. Skura.
Yes, thank you, Your Honor. The comment that the doctor just made has no relevance based on the question that was actually answered.
Your Honor, if I may respond.
Yes.
Your Honor, if you recall during pretrial, opposing counsel pointed out to you that the four prongs of negligence include proving that the type of harm actually occurred. Now, Dr. Cannon is explaining to us that Genesis Petrillo may have actually died of alcohol poisoning. Now, if Genesis actually died of alcohol poisoning, then that would disprove the third prong of negligence. This is directly going to the burden. Therefore, this is very relevant testimony, and it is admissible.
Yeah, if you'd like to be heard, Ms. Skura.
I would. The percentage of alcohol poisoning that opposing counsel is bringing up is not necessarily relevant. There's been no foundation laid for the fact of what a 0.16% blood alcohol level does or would cause.
If I may respond. My apologies.
Yes, Ms. Colson. Yes.
Your Honor, all I've done so far is ask about what the other cause of death is. My next question was going to be asking if it wasn't necessarily 0.16, what it could have been and what the effects would have been. Therefore, the foundation for how this affects Ms. Petrillo is about to be laid in my next question.
Yes, I believe that this is in the process of laying the foundation, so I will overrule the objection and allow Ms. Colson to continue this line of questioning.
May I continue?
Yes, you may. Thank you.
Now, if you'll finish up your response from the earlier question, what was the alternate cause of death you were telling us about?
Of course. Dr. Kwan, the treating physician, as I've been mentioning throughout this, his initial idea was alcohol poisoning, but he ultimately rules it out because Petrillo's blood alcohol concentration only measured up to be about 0.16%, which on its own is almost certainly not lethal. However, it's very likely that Petrillo's BAC was much higher before when she was at Peony Estates.
Now, Dr. Cannon, if Genesis Petrillo's peak BAC was not 0.16% when she first started showing symptoms, then what could it have been?
It's just impossible to say for sure. Unless we have a full accounting of what exact time Petrillo drank something and what exact time and what exactly it was, we can't get a remotely accurate estimate on BAC.
Now, if Ms. Petrillo's BAC was high enough, could it have caused her death?
If it was high enough, yes, it could cause her death, absolutely.
Now, would we have any reason to believe that Genesis Petrillo's BAC could have been at a high enough level to cause death?
Based on the treating physician's report, no. But based on the affidavit of the eyewitness that I mentioned earlier, yes. We do know that Petrillo was vomiting for a very long time before 911 was dialed. First responders got there and they had to perform CPR. And I'm sure we can all assume that when she was on the way to hospital, she wasn't consuming more alcohol. So that's a long period of time where Petrillo was not consuming any alcohol, which suggests that the peak BAC could have been pretty high.
Thank you, Dr. Cannon. I have no further questions, Your Honor.
All right. Thank you, Ms. Colson. Ms. Skura, if you have anything on cross-examination, you may begin whenever you're ready.
I do. Yes, Your Honor. Dr. Cannon, with respect to the Exhibit 10 that has been admitted into evidence and has been displayed on the screen earlier, can you attest from those test results where that bottle of wine came from?
Oh, yes. It's in the description toward the bottom of the exhibit.
Mm-hmm. And may we pull up that exhibit, Your Honor, for the witness to view and for yourself as well?
Yes, you may. I will say I'm currently on my phone, so I probably don't have the greatest view when it does get pulled up. So if someone could at least read out what the relevant portion is, rather than have my face directly up in the camera as I'm squinting at the small type.
Which exhibit would you like?
Would opposing counsel like me to pull it up for her? I have it still queued up on my screen.
Well, that would
Whatever works easier for you guys.
That would be very kind of you. We have it ready, but thank you.
Are you able to see it?
I am. If you were to scroll down, Dr. Cannon, can you tell me where, if you can see this clearly, where does it say that this bottle was found?
Well, it's on the second heading from the bottom on the description from that. It says, sample collected on June 9th, 2019 from the inside of an empty bottle of Caro wine found in the trash by RRPD officer C. Veneria.
Does it say in that exhibit that that particular bottle of wine was from Peony Estates or found on Peony Estates property rather?
I mean, not in that particular line, but I'm sure from context we can infer the general area. If it wasn't from Peony Estates, I wouldn't know why Dr. Kwan, the treating physician, would have had this test done.
Well, perhaps not, but I would say that based on your testimony as a doctor, you don't necessarily know whether or not that was the bottle that was given to Ms. Petrillo earlier that evening, correct?
Objection, Your Honor?
Yes, Ms. Colson, if you'd like to elaborate.
Your Honor, this question has already been asked and answered. As Dr. Cannon's already told us in earlier testimony that he was made aware of where this bottle was found in order to prepare for today's trial, and that this analytical report was done on the Caro wine bottle found in the trash at Peony Estates.
I think what she's asking is a different question. She's not asking, where he found it or where he got the test results, but she's asking how he knows what specific bottle this is. So I'm going to overrule that objection at this time. Ms. Scurry, you may continue.
Yes, Your Honor. Dr. Cannon, what I'm getting to is it's a fact that you have no idea that this level of organophosphate in this bottle was necessarily the same exact organophosphate on a molecular level as was found in Ms. Petrillo's body.
On a molecular level? I'm sorry, counsel. If things are the same on the molecular level, like if isofenfos in one area is isofenfos in the other, they contain the same molecules. So I don't really understand your question here.
Well, Dr. Cannon, you are the doctor, and clearly I'm just a lawyer. But specifically, can you tell me if the source of the organophosphate was the same from this bottle definitively to what was found in Ms. Petrillo's body?
Oh, okay. As a source, no, I cannot say that.
Okay.
I can just say based on context and other facts that I know that this is the likely source.
Thank you. And thank you to defense counsel. Your Honor, may we pull this exhibit down?
Yes, you may.
Okay. Thanks again for that. Going back to the isofenfos that was found in the bottle, you said it was 91 mcg, correct? Is that a lethal level? Because you said dosage is the poison, so is 91 mcg?
Objection, Your Honor. Compound question. I ask the opposing counsel break down the question into portions.
Ms. Gurr, if you could just please rephrase the question.
I will, thank you. Dr. Cannon, is 91 mcg, yes or no, a lethal level of isofenfos?
That's the problem. I don't know.
Okay. May you speculate, yes or no, on the blood alcohol, pardon me, you did speculate on the blood alcohol level of Ms. Petrillo earlier, did you not? Yes or no?
I speculated that was higher, but I didn't speculate to any exact numbers. So you're correct that I did do some speculation here.
Objection, Your Honor. I'm sorry if this is a little late, as the witness did answer the question, but opposing counsel is testifying by saying that Dr. Cannon was speculating to the levels. He stated the levels. So if opposing counsel would rephrase her question.
Well, he did already answer the question. Also, I don't believe that she was testifying by characterizing what he had said. I'm going to overrule that objection.
Dr. Cannon, the reason I asked that question, and I will clarify it. So isn't it true in your earlier testimony, you said that you believed that Ms. Petrillo's blood alcohol level could have varied throughout the night?
It could have varied. I mean, blood alcohol concentration doesn't really vary. It follows a constant track. The possible BAC of the peak, that's what varies because we don't know. So in that sense, you're correct. Yeah.
She was, Ms. Petrillo was tested at 0.16%. Is that a lethal level?
Oh, absolutely not.
Okay. So the determinations that you're making are not based on evidence that you personally collected. Isn't that correct?
Well, the determinations I'm making are based on evidence. Based on the evidence I was able to find from the night, I can say it's very likely that the BAC was higher. But again, based on the evidence, I can't say what it exactly was.
Dr.
My job as a doctor, sorry, my bad.
My question was, your determinations are not based on evidence which you personally collected. Isn't that correct?
Well, they never are. When I'm in these cases, I always have to review things I didn't personally collect. So yes.
All right. And you pointed out 3 other causes of death for Ms. Petrillo other than pesticide poisoning, correct?
Yes, other than pesticide poisoning.
Mm-hmm. And alcohol poisoning offers no answer as to how organophosphate was found in Petrillo's stomach, correct?
That theory alone, yes.
And it doesn't explain her contracted pupils?
It does not.
Does it explain her constricted blood vessels?
It does not.
Another potential cause of death you listed was allergies, correct?
Yes.
And the vast majority of food and beverage allergies are detected well before the age of 27, are they not?
Yes, though they tend to develop later in life. Allergies are by no means an exact science.
And allergies still fail to explain some of Ms. Petrillo's symptoms, correct?
Yes, there's no theory here that explains everything. That's why there's no definitive cause. If there was a theory here that explained everything, my testimony would be much more simple and I would have already been gone probably.
And you stated that hepatic disease could have been the cause of death, did you not?
Yes.
But isn't it true that hepatic disease would likely present itself much earlier considering Ms. Petrillo's drinking habits?
Yeah, this theory is a little bit weird. So while that is true, it probably would have presented itself earlier in some way, shape, or form. Ms. Petrillo had not done any regular checkups for about 3 years. So we would not know what we would, at least from medical way, there's a 3-year gap where we don't know if she developed hepatic disease or not.
And
Again, it's another fact in this case that shows that we just don't have enough facts.
So isn't it true that hepatic disease offers no answer as to how organophosphate was found in Genesis Petrillo's stomach, right?
Yeah, like I mentioned, no theory here is perfect.
And of all the theories that you brought up in your report and on the stand today, none of them are highly likely. Isn't that correct?
Nope, none of them are highly likely, like at all, pretty much.
Yet Ms. Petrillo still had organophosphate in her stomach, correct?
Yep, like I mentioned, there was that test of acetylcholinesterase that detected isofenfos.
And isn't it true that the only contents of Ms. Petrillo's stomach that evening was the wine?
Yes, though stomach acids dissolve certain other substances over time because, you know, that's how our stomach works.
But if that's how the stomach works, the wine was still found, was the only thing found in her stomach. Isn't that correct?
Yeah, you're absolutely right.
Okay. So despite the less likely causes you cited in your report, you would agree with Dr. Kwan's conclusion that the most likely cause of death was indeed pesticide poisoning?
Yes, it's worth noting most likely does not mean more likely than not. You and I have already been talking a lot about how there's a lot of very unlikely theories here.
But still, going back to my question, you would agree that pesticide poisoning is the most likely cause of death?
Yes.
Nothing further, Your Honor.
All right, thank you, Ms. Skura. Do we have any redirect from Ms. Colson?
Yes, Your Honor.
All right, and also, I don't know where we're at on time. I'm just taking a look at the time. It seems it's about almost 4:10. I don't know how we are on in terms of the time allotment given, but I guess if we just keep an eye on that, and whoever's been timing, let me know if we're getting close to the end of that. But you may go with your redirect.
Dr. Cannon, opposing counsel was asking you about the Cara wine bottle found in the trash. So I want to talk about that real fast. Now, if we were to discover over the course of this trial that that bottle was actually found in the same dumpster as bottles of isofenfos pesticide open containers, then would that explain the levels of contamination in the bottle?
Oh, absolutely, yes.
Now, I also wanted to clarify for the jury, now the 91 micrograms found in that bottle, is that a dosage for Genesis Petrillo?
Absolutely not, for reasons mentioned earlier. We don't know when Genesis consumed, since we don't know when the bottle was contaminated, that's by no means a dose.
Now, finally, doctor, we were talking about the most likely cause of death. So I want to ask you, is most likely the same as medically certain?
By no means. Most likely is not the same as medically certain, and most likely is also not the same as more likely than not.
Thank you. No further questions, Your Honor.
All right, thank you. Do we have any recross based on that redirect?
No, Your Honor.
All right, thank you. Now, Dr. Cannon, I guess you may be excused. Obviously, you can stay in the chat and watch the remainder of the trial if you so choose. Do we have any further witnesses for the defense?
Yes, Your Honor. The defense calls Ms. Austin Lewis to the stand.
All right, thank you. And you may begin whenever you're ready.
Good afternoon. Please state your name for the court.
Hi, my name is Austin Lewis.
Ms. Lewis, what is it you do for a living?
I'm the head winemaker over at Peony Estates.
How long have you been involved in the wine business?
I would say forever, really. My mom used to work in the wine business, and then back in 2018, Danny Francasio actually offered me a job at Rosie and Pedro's. And then in 2015, when Harper Martini was opening up Peony Estates, she asked me to join her.
Ms. Lewis, what does a head winemaker do?
I mean, I do everything really. So from handling the growing of the grapes to harvesting, crushing the grapes, producing the wine, fermenting, all of it. I also like to make sure that the tours that we host are going well. So I supervise those as well. Harper handles more of the business aspects, and I get to be in charge of the creative side.
Ms. Lewis, can you tell us a little bit about how Peony Estates produces its wine?
Of course. So firstly, we only make one blend a year just to promote like exclusivity of our brand. And after we crush the grapes and we put them in the bottle, we bottle it sideways for a month, and then we make it upright for the rest of the fermentation time. But don't tell anyone though.
Ms. Lewis, does Peony Estates use pesticides?
Yes, we do.
Who is in charge of pesticide use?
I am.
Ms. Lewis, do you take pesticide use seriously?
Very serious. It's very important.
How do you ensure the pesticide you spray on your grapes doesn't end up contaminating the wine?
We have company policy that follows the Midlands rules.
Do you have any other company policies?
Yes, we do.
How do you store your pesticides?
We have a separate storage unit that is far away from our main producing area, and that's where we put all of the pesticides that we use.
What happens during the actual spraying?
So before we can even spray the inside of our facilities, we have to remove any wines or wine precursors. We also have to wrap up any machinery that's stationary that we can't move. And then we can spray the room. And then 48 hours later, we can return everything that we took out and also unwrap the stationary machinery. And this is in accordance with company policy.
Ms. Lewis, who uses pesticides?
Trained employees.
And what do you do with the canisters after?
The ones that are empty, we throw away in our big dumpster. The ones that are even half used, we also throw away just as a precaution. Any of the ones that are unused, we return to the storage facility that we have.
Ms. Lewis, were pesticides used in the lead up to the wedding rehearsal dinner on June 7th?
Yes, they were. We had just finished coming off of a mite problem in our producing area, so we just sprayed as a precaution.
Did you follow company policy?
Yes, we did.
What did you do with the pesticide canisters after?
The ones that were completely empty, we threw away. The ones that were partially used, we also threw away. The ones that were unused at all, we returned back to the storage facility as in accordance with company policy.
Ms. Lewis, are you familiar with the allegation that Genesis Petrillo died due to a contaminated bottle of Peony Estates wine?
Yes, I am. And while I personally wasn't at the rehearsal dinner, I know that this was based off of the Kira wine that he drank.
Objection, Your Honor, if I may be heard.
Yes, you may.
This is testimony based on hearsay. As you just said, she heard that Genesis Petrillo died as a result of something ingested at the wedding dinner. Any testimony that she has predicated upon that would be testimony based on hearsay, and it's inadmissible.
Ms. Parsons, you care to be heard?
Your Honor, the statement is not hearsay. Ms. Lewis is not offering a specific statement given by a specific individual. This is a detail that would be well known by those involved in the case and is therefore not hearsay.
Your Honor, if I may be heard.
Yes, Mr. Kanduri.
The fact that it is well known does not detract from the fact that it is still testimony based on hearsay.
I'm going to agree with Mr. Kanduri. It might be hearsay, but I believe it's speculation, as we don't have any testimony as of yet. This is based on personal knowledge, unless she is. Yes, Ms.
I
Parsons.
do have a different response. This is also not offered for the truth of the matter asserted. It's simply offered to state what happened next in the trial. I'm sorry. It's to state that she knows the details of the case.
I will allow her to testify that she knows about the death, but I will strike the part as to the cause of that death. As at this point, I don't know that she has any personal knowledge as to what caused it, and you may proceed from there.
Yes, Your Honor. Ms. Lewis, has Peony Estates ever had any problems with pesticide use?
No, nothing major.
I'm sorry, what was that, Mr. Kanduri?
A leading question. She asked if Peony Estates has had any problems with pesticide use before. That implies that either they did have problems, or they didn't have problems, and it suggests the answer in the question's frame.
I'm not going to find that that's leading necessarily. She's not necessarily, implying one proper answer over another. But I would, Ms. Parsons, just be careful with the wording of your questions as you go forward.
Yes, Your Honor. Ms. Lewis, I'll ask again, has Peony Estates ever had any issues with pesticide use?
No, we've never had any major issues. We've only ever had a couple of citations.
What happened?
We've had them in July and July of 2018 and May of 2019. Riley Atkins O'Keefe, who's the health inspector, just happened to come by when we were in the middle of getting ready to spray our producing areas, and we got cited for those.
Did you do anything after those citations?
Of course, like I said, pesticide storage and use is very important. So we made sure that after those citations, we remedied the problems by building a storage shed that was closer to our main building area. I also made sure to put signs around the building reminding employees to wash their hands and change their clothes immediately following pesticide use. And I also personally increased my vigilance.
Ms. Lewis, has Peony Estates wine ever been tested for pesticides?
Yes, we have.
When was that?
This was during one of the health inspections with Riley O'Keefe.
How many wines were tested?
He selected 20 bottles of our wine and tested them for pesticides.
Were you using pesticides on your grapes at this time?
Yes, we were.
What did the health inspector find?
He didn't find any unsafe levels of pesticide, and that's why we were able to continue to be open for a business.
Ms. Lewis, do you trust that your employees would come forward if anything had gone wrong?
Yes, I definitely do.
Did they ever?
Nope, they never have. And like I said, I trust my personal vigilance and the employees' efforts to make sure that they're following everything up to code at Peony Estates.
Thank you, Your Honor. At this time, I have no further questions for the witness.
All right. Thank you, Ms. Parsons. Mr. Kanduri, if you have anything on cross-examination, you may begin whenever you are ready.
Yes, Your Honor. Good afternoon, Ms. Lewis.
Hi.
I'd like to talk about your relationship with Mr. Francasio. Your family used to work for him, right?
My mom did, yes.
And you believe that during that time, Mr. Francasio mistreated your family, yes?
I believe that he mistreated her by firing her, but not while she was working with him.
Well, you do blame Mr. Francasio for your mother's death, right?
Objection, Your Honor, relevance.
Your Honor, if I may be heard.
Yes, you may, Mr. Kanduri.
As being an agent of Peony Estates in this case, and as Mr. Francasio's winery is a rival winery, bias between the two parties is incredibly important to the outcome of today's case.
Yes, I tend to agree with Mr. Kanduri, as we've had a couple other objections on the same grounds, and I think the bias and credibility as to witnesses with this regard, I think that's an appropriate question. I'm going to overrule the objection, allow you to continue your questioning, Mr. Kanduri.
Yes, Your Honor. Now, you blame Mr. Francasio for your mother's death, right?
I do, yes.
And one of the reasons why you accepted Harper's job offer was because you were tired of being under Mr. Francasio's thumb.
Yes, I was. I found that at Francasio's winery, I didn't really have the creative freedom that I wanted to be as a wine producer, and I would have a better chance at Harper's winery.
And now you own 10% of Peony Estates, yes?
Yes, I do.
So if you lost it, so if this trial was found in favor against Peony Estates, you would lose that 10% share, right?
Yes, that's how the math works.
I would like to direct your attention to the pesticide practices on Peony Estates. You used organic pesticides, right?
Yes, in the beginning, we started out using organic pesticides back when the company was really young, but we found that they were very, very expensive.
So you switched to conventional chemical pesticides in 2018.
Yes, we did. Unfortunately, those are less pricey and take care of the problem quicker.
As a matter of fact, Ms. Martini pushed for the use of these pesticides way back since 2015, right?
Yes, she did. As you know, she is the main businesswoman in this venture, and I only handle the creative side. So,
despite your advice to the contrary as head winemaker?
Yes.
Now, all the wines at Peony Estates only take a year to produce, right?
Yes, we only bottle for a year.
So the 2018 grapes were the first batch that were exposed to chemical pesticides?
That would have been the 2017 grapes.
You switched to chemical pesticides in 2018, yes?
Yes, that is correct.
So the 2018 grapes that were growing and harvested for the 2019 wines were the first that were exposed to chemical pesticides.
Yes, that is true.
Which means that the wines sold in 2019 would be the first wines with a chance of containing chemical pesticides, right?
Yes.
Now, I'd like to talk about the Peony Estates vineyard itself. You throw away some of the grapes each year because they don't have proper drainage, right?
Yes, that is true. We are located on a slope, so I always make sure to rope off the ones at the bottom because they would have higher levels of pesticide.
But in 2018, you weren't there to see that those grapes were thrown away, were you?
Nope, I personally wasn't there, but as I stated earlier, I am 100% confident in my employees' efforts.
Despite the fact that it's not usual for you to not monitor this practice in person, right?
Yes, I unfortunately had a family emergency just 1 year and couldn't be there.
And your employees left you in the dark.
Nope, they didn't leave me in the dark, but I wasn't informed of anything wrong that happened. Like I said, if anything had gone wrong, my employees would have let me know.
I'd like to talk about the pesticide storage. You received a health code violation in June of 2018, correct?
Yes.
This was for storing pesticides too close to the cellar.
Yes, and we were in the middle of about getting ready to spray that day, so that's why they were there.
And it wasn't until you received the citation that you moved the storage to a safer unit, right?
Yes, at Riley's advice, we did follow the instructions that he gave us.
But despite this change, you were cited again in 2019 for the same reason, pesticides being too close to the bottling area.
Yeah, it was just a case of bad timing, really.
But Miss Lewis, you yourself admit that this is a pretty convenient excuse you gave the health inspector, right?
I wouldn't say excuse per se, but it was just a matter of bad timing, and I can see why Riley wouldn't believe us.
Is that a yes to my question, that this is a convenient reason to give to the inspector?
Yes, it is. But like I said, it was a case of bad timing.
Thank you, Your Honor. No further questions.
All right. Thank you, Mr. Kanduri. Ms. Parsons, do we have any redirect?
No, Your Honor.
All right. Thank you. Ms. Lewis, we appreciate your testimony. You are free to go.
Thank you.
Obviously, you can stay in the chat, watch the remainder of the trial, which at this point, I believe, do we have any further witnesses for the defense?
No, Your Honor.
All right. So I believe that would be the defense would rest at this time. We'll take just a couple minutes. I'm going to set an alarm on my phone for 3 minutes. I'll try and set my computer back up, and then we will go with our closing arguments. We can be at ease until then.
All right, everybody. It's been just about 3 or 4 minutes since we began the recess. If we'll have those who will be giving the closing arguments for both sides, if you could turn your video on when you're ready, just so that I know who will be going, and then we can begin. Okay, thank you. I see Ms. Coulson is on, and on behalf of the plaintiff. All right, we have Mr. Kanduri. I believe the plaintiff will go first, and then would you like to reserve any time for rebuttal, Mr. Kanduri?
Yes, Your Honor. I ask that any remainder time after the closing be reserved for rebuttal.
Okay, thank you. Yes, ma'am.
Would Your Honor prefer I keep my camera on during Mr. Kanduri's closing statements or off?
I was going to say I would prefer if you turn it off. I just want to see who would be delivering the arguments. Yes. And when Mr. Kanduri is done, then you can turn yours back on. Thank you. All right, Mr. Kanduri, whenever you're ready.
Yes, Your Honor. May it please the court. Another year, another inspection, another excuse. Your Honor, opposing counsel, and members of the jury, you're here in court today because an innocent life, that of Genesis Petrillo, was abruptly taken away. But what killed her wasn't a psychotic or vicious attack. No, what killed her was a preventable mistake, one that never would have happened but for the defendant negligently making excuses instead of amends for their failures. And now they're here before you making excuses yet again. They've cobbled together a convenient story to hide the liability of their client, Peony Estates. But we, the plaintiff, have placed the truth plainly before you, that Peony Estates is liable for negligence per se. Now, as the plaintiff in today's case, we bear the burden of proof. We must show by a preponderance of the evidence that Peony Estates is liable. It means that after looking at all the facts, looking at all the evidence, and making all due considerations, if you think that Peony Estates is more likely than not to be culpable for what happened to Genesis, you must find them liable. Today, we are pursuing negligence per se. The law requires us to prove 3 things: that the defendant violated Safety Statute 12100, that the defendant's acts or omissions caused a type of harm that the statute was intended to prevent, that the defendant's breach of the statute was a direct and proximate cause of the plaintiff's harm. Now, if you remember, direct and proximate cause, my co-counsel, Ms. Shelby Johnson, I ask you to remember that at the beginning of today's trial. Because through the testimony that we've elicited, through the evidence and facts that we've shown you, we've proven just that but for Peony Estates keeping toxic pesticide next to their wines, Genesis Petrillo would still be here with us today. Your Honor, members of the jury, the facts of the case are laid bare before you, and the truth they tell is crystal clear. In 2014, after leaving Danny Francasio while working as a cellar hand, Ms. Martini decides to set up her own winery, Peony Estates. Now, she and Peony Estates are supremely confident about their ability to produce quality wines in the competitive Midlands market, but from the get-go, cracks begin to appear. We heard from Mr. Francasio that on the 2nd year of their making wines, she started frantically emailing him about help with how to manage the pest problem. Mr. Francasio was so concerned about the safety of the public that he decides to ask Lonnie Paris, an investigator, to dig further into Peony Estates' pesticide practices. And the first year, on the first inspection, we heard from Inspector O'Keefe that he had to cite Peony Estates for having pesticides stored too closely to both the wine storage and the kitchen. But Ms. Martini just gives him an excuse. It was a mistake. So he lets them off with a warning. And then in 2018, Inspector Atkins arrives for a 2nd year on the 2nd inspection. This time, there are issues with storage again. Ms. Martini leads him nervously to a storage that is a safe distance from the pesticides, but Inspector Atkins suspects something is wrong. And he's right to do so, because he told us when he asked Austin Lewis, Miss Lewis revealed the truth. Pesticides were actually stored dangerously close to the bottling facility, and he cites them yet again for this violation. And again, Ms. Martini gives him an excuse. It was convenient. As a matter of fact, just 4 days later after the inspector came, we heard that Lonnie Paris found pesticide cans littered all over the bottling facility. Another year passes, and in 2019, Inspector Atkins arrives for his 3rd inspection. Same problem.
While the pesticide storage was moved to a safe distance and Ms. Martini assures him that there are no pesticides to be found anywhere, by the time they come to the bottling facility, members of the jury, Inspector Atkins told us that he found 4 health code violations, all pertaining to having pesticides too close to the bottling facility. As a matter of fact, on that same day, Lonnie Paris told us that when she went to the wine cellar, she found an open bottle of pesticides next to a bottle of Cara wine. A bottle of Cara wine that hadn't been moved in a month. A bottle of Cara wine that the next day, witnesses saw handed to Genesis Petrillo. A bottle of wine that was so laced with pesticides from exposure that it killed Genesis Petrillo. Now, members of the jury, the facts of today's case tell one cohesive story, but the facts you haven't heard say the same. Did we hear any testimony from the plaintiff about how they could counter what Inspector O'Keefe saw? No, no relevant expert testimony. Their expert could not even agree that the likeliest cause of death wasn't pesticide poisoning. Did we hear any reliable testimony as to how Peony Estates was able to modify and improve their practices after each inspection? No, we only heard more excuses. Now today, a year after Genesis Petrillo's death, after we make another inspection of the facts, members of the jury do not let Peony Estates make one more excuse. Find them liable for negligence per se, or someone else will have to pay with their life. Thank you.
All right, thank you, Mr. Kanduri. And now, who do we have again for the defense? Is that Ms. Colson? Yes, okay. Ms. Colson, whenever you are ready, you may begin with your closing.
Before I begin, can you see and hear me clearly?
Yes, I can. You're all good. Thank you.
Your Honor, opposing counsel, may it please the court. The dose makes the poison. That's what my co-counsel, Mr. Vinaya Krupp, said to you today in opening statements. Because in today's trial, the dose is everything. Now, Mr. Canbury just told you that Genesis Petrillo died of organophosphate poisoning simply because there was some amount of it found in her blood. But what Mr. Canbury can't tell you is the actual amount of isofenfos that Genesis actually consumed. Now, the plaintiff tried to distract you by telling you stories about sealed pesticide containers sitting next to sealed bottles. But they can't get around the fact that they failed to provide a dosage for Genesis Petrillo, and they failed to prove that this dosage wasn't within the FDA's safe levels. The dose makes the poison, so ladies and gentlemen, if there is no dose, there is no poison. What happened to Genesis Petrillo was a tragedy, but it wasn't negligence. Because on the afternoon of June 7th, 2019, Genesis Petrillo had an afternoon of stressful wedding planning and an exciting evening of a wedding rehearsal. Genesis drank too much alcohol that night, more alcohol than her body could handle, and as a result, on the morning of June 8th, 2019, Genesis died of alcohol poisoning. Now, the plaintiff holds the only burden in this trial. They had to prove to you by a preponderance of the evidence that every element of the claim of negligence was more likely than not committed. So 1, they had to prove to you that the defendant violated a statute. 2, that the statute in question was a safety statute. 3, that Genesis Petrillo died as a result of this. And 4, that the plaintiff is a member of the statute protected class. Members of the jury, we don't contest that the statute is a safety statute, and we don't contest that Genesis was a member of this protected class of people, but in order to prove their burden, to meet their burden, the plaintiff had to prove each and every element by preponderance of the evidence, and they have failed to do so because they have failed to prove the third prong of negligence, that Genesis Petrillo died as a result of Peony Estates' actions. And they failed to do this because they have failed to prove that Genesis died of pesticide poisoning. Without causation, ladies and gentlemen, there is no poisoning. Now, let's first take a look at that causation that Ms. Johnston mentioned to you and Mr. Canbury mentioned again. In order to prove that Peony Estates is liable for Genesis Petrillo's death, the plaintiff had to prove to you that both direct and proximate causation. Direct causation is proven if the plaintiff can prove that without Peony State's actions, Genesis never would have been hurt. They failed to do this because they failed to prove that pesticide poisoning caused Genesis Petrillo's death. And as a result, they failed to prove proximate causation, that the plaintiff's harm was a reasonable, foreseeable result of Peony State's actions. This is disproven if the plaintiff can't even prove Genesis died of pesticides. Now, the idea of any pesticides in the food or drink we consume may seem alarming, but the plaintiff is relying on this alone to prove their case. The fact of the matter is that many of the foods we eat contain trace amounts of pesticides. That's why it's the FDA's role to ensure that pesticide levels don't exceed certain amounts that are deemed safe. You heard about these limits from Dr. Cannon and from their own witness, O'Keefe. And you heard about how isofenfos has a reporting limit as well. So the plaintiff wants you to believe that any pesticides would kill Genesis, but this is not supported by the facts. Then there's the utter lack of dosage information for Genesis Petrillo. The plaintiff called Atkins O'Keefe to explain to you that pesticides can cause death, but this same expert couldn't even tell you how much pesticides Genesis Petrillo consumed. And this is because the only tests that were ever run on Genesis Petrillo only tested for the presence of isofenfos and not the amounts. Now, as the defense in today's trial, we have nothing to prove to you. We have no burden, and we do not have to prove the Genesis Petrillo's cause of death. But despite this, Dr. Cannon still provided you with relevant evidence that Genesis Petrillo may have actually died of alcohol poisoning. Even if you'd think that organophosphates caused it, we also heard from Austin Lewis. Austin is the head winemaker at Peony Estates, who has everything to do with the winemaking process and the use of pesticides. She walked you through every step of their pesticide usage and explained to you how they did not break these statutes. Now, the plaintiff also called Francasio to talk to you, but Francasio has never even been to Peony Estates. Francasio has never seen how they store their pesticides. Francasio has never seen how close where their pesticides are stored. Now, they also called Atkins O'Keefe to the stand to explain to you about how all these rules they violated, except O'Keefe also told you that every time they visited, they made recommendations, but they never stopped them from producing wine. Atkins also told you that every time she visited and told them to move their pesticides, Peony Estates complied. They moved their pesticides. They built 2 different buildings to store it to please Atkins O'Keefe. Now, finally, the plaintiff also called Lonnie Paris to talk to you, but Lonnie Paris is just here looking for a story. Her entire testimony was telling you how she was looking for the next big break in her career. Now, members of the jury, Genesis Petrillo's death was nothing short of heartbreaking, but it wasn't due to negligence, and it wasn't because of Peony Estates. Ladies and gentlemen, Peony Estates is not liable for Genesis Petrillo's death because the dose makes the poison, and there was, and still is, no dose. Without proving Genesis Petrillo's cause of death, the plaintiff has been unable to meet their burden. You must find in favor of the defense. Thank you.
All right, thank you, Ms. Colson. I believe, Mr. Kanduri, you have rebuttal. I'm not sure quite how much time you have remaining, but whenever you are ready, I see your video is now on. Whenever you are
Your
ready.
Honor, may I request a time check before I proceed?
Yes. Who has been keeping time on behalf of the plaintiff's team?
Your Honor, I currently have rebuttal time at 2:09.
Okay, thank you. Mr. Kanduri, you have 2 minutes and 9 seconds remaining for your rebuttal. Begin whenever you're ready.
Yes, Your Honor. Members of the jury, in today's case, the burden is by a preponderance of the evidence. When you go into that jury room later, you need to decide which story is more likely. And I ask you just that. What's likely? Is it likely that Austin Lewis, having a 10% share in Peony Estates, being head winemaker of Peony Estates, gave a reliable testimony today? Is it reliable that the FDA, after giving 4 health code citations while being told by Ms. Martini that there were no problems, was able to give you unreliable testimony? Members of the jury, I ask you that if having problems every year with every inspection and every single time they give excuses, how could Peony Estates possibly have not made the same mistake again? Members of the jury, Ms. Colson came before you and she told you that there is no dose and there is no poison. Well, if dose is such a crucial matter, why did Dr. Cannon, their expert, disagree that the likeliest cause of death was pesticide poisoning? Because the dosage doesn't matter. The fact that the poison is there does. Members of the jury, we heard today that there was poison found in Miss Genesis Petrillo. And the dosage, we also saw that there were lab reports that showed that Peony Estates wine, particularly a bottle of Cara wine that Genesis drank from, was found in a dumpster outside of Peony Estates that was full of isofenfos pesticide. Moreover, Ms. Colson went on to say that it was the FDA's job to shut down Peony Estates. That was the FDA's job to protect the public. But the FDA is not on trial today. Inspector O'Keefe is not on trial today. Peony Estates is. It's their responsibility under Midland's Code 12100 to keep the public safe from contamination of their food with pesticides. And we saw that today there was more than one chance where they could have made a change, but instead all they made were excuses. In the end, Genesis Petrillo paid the ultimate price. I ask that you find Peony Estates liable for negligence per se, or else after another year, another inspection, another excuse, another person will pay with their life. Thank you.
All right, thank you, Mr. Kanduri, and thank you to everybody who participated. I think we're now officially done with the trial. So all of those participants, if you guys would like, if you can turn on your videos and receive a little bit of feedback from both myself and my co-judge, if you guys are interested in hearing some of that. Hang on. If you give me just 1 second. Let's see. My computer internet went out just one last time while I was in the middle of the rebuttal. So I'm trying to.
All right, here we are. Sorry about that. I was trying to go back from my phone to my computer so I could see everybody during this portion. Looks like we've got everybody. I've been talking for a while throughout this whole trial, objections and everything. So Judge Baraki, I know that, I guess that's not how you pronounce it.
It's close. It's close.
Okay. We'll allow you to introduce yourself and start with some of the feedback that you've got.
Yes, just for clarification, have you submitted your ballot already?
Yes, I have.
Cool. I'm going to go ahead and real quick just shoot a text to Scott. Do you remember what courtroom we are?
We are courtroom 5.
Awesome. Thank you. Well, good job, guys. You made it through a weekend of competing. First tournament, I can't imagine any of you guys have already competed, and if so, y'all are truly warriors. I want to keep them general because I know that y'all have coaches who will give you guys advice on things. One thing that I noticed a lot was that witnesses really like to fight on cross. They didn't like to just answer a question, and sometimes it's good to fight, but what ends up happening is that you fight so much on questions that don't matter that we don't actually see you as just, some random person who's like is an eyewitness to what happened or who knew one of the parties, and we see you as someone who's like just a secret agent by the defense attorneys or the plaintiff attorneys, whoever it may be. And I guess on a positive note, Austin Lewis was one of the witnesses. How do you pronounce your last name? Hema, you did a really good job, I think, of not fighting unless you really needed to. And I didn't find you to be particularly biased in any way. But I noticed that for Like that's not the case for most of the other witnesses. As a general rule as well, speak slower. It's really easy with nerves to want to talk a lot faster than you even realize, and especially on this online format. A lot of times it was difficult to catch up on exactly what you were saying, especially attorneys in objection battles. And lastly, listen carefully to the judge, especially during these objection battles. I know sometimes they can get passionate, but you most certainly want to let the judge speak when they're talking. And to once the judge has made a ruling, it's generally a pretty good practice to not try to make another argument or say, "Oh, can I be heard one more time?" Typically, once the judge has made their ruling, obviously, Judge Olson did not seem to be particularly annoyed by it, but you will most certainly have judges who will not be happy if you try to add in additional comments afterwards. Overall, I have a few like other individual comments, but I also recognize that y'all have coaches. Real quick, I did mock trial for 4 years at Furman University in Greenville, South Carolina, and currently am a 1L at Georgia State. And that's about all I've got.
All right, great. Thank you, Judge, not Barucki, but close enough to Barucki. I'm Kevin Olson. Obviously, I was presiding over this trial. I graduated from Wake Forest Law back in 2019. I've been working as an assistant district attorney here in Winston-Salem, North Carolina for a little bit over a year now, mostly just trying misdemeanor cases. So I've been in a courtroom in a much different setting, district court, trying misdemeanor criminal cases as opposed to civil cases like this. This is obviously much more complex and a lot more witnesses and everything than what I've been dealing with recently. But I just want to say off the bat, I think you guys did a really good job. The last time spot on Sunday afternoon, I'm sure you guys are all exhausted. I judged around this morning as well, so I'm pretty tired myself. So first of all, just congratulations for competing, for finishing, and a job well done. I think you guys, you were clearly prepared. So I mean, I think pretty much everything that's already, I would echo pretty much all the sentiments that have already been said. There's one other thing. I think early on there was a that I don't think was ready to be pulled up, and we ran into that issue once or twice. And I know this Zoom format is weird. I've never done any hearings or trials via Zoom, and I don't know what your guys' schedule is like. This might be the first competition you've been doing, but if you just have that kind of stuff prepared so that we don't have to sit there for a minute or two trying to sort through. I know at one point opposing counsel was able to help us out, which was, I really appreciate that, the sportsmanship aspect of that, and also help things moving along. But just to be sure to be prepared with your exhibits and your evidence if you're going to be doing that, and just be cognizant of the online form you're using. I noticed just kind of generally, for the most part, on cross-examination, you guys are really good with making sure you're asking leading questions. I know with Ms. Parsons and Mr. Kenduri in particular, I just happened to notice and write down good leading. I don't remember any specific examples, but I guess you guys must have a few questions in particular that really impressed me. So well done to you guys. Everyone had their moments where everyone had things that I thought you did really well. So that was, I think you guys all did a great job. I don't know if Judge Barucki, if you got any other comments. I don't want to get into too many particular individual moments, just because, as he said, you guys have had coaches who know specifically how to tailor their feedback to you guys. But if you have any questions for me or Judge Barucki, please feel free.
Yeah, one more thing on that. As a forewarning, I don't know if your teams view ballots after the fact. I am not like most judges that will start at like an 8 or a 9 and just give you all 9s and 10s. I started a 5, and I see a 5 as what I think is like an average collegiate AMTA attorney. So my scores can be low, my point differentials on certain things can be high, and please don't be upset if you get a 6 or a 5 like that. That is, like, in my eyes, a good thing, because I can't stand judges that gave 9s and 10s on everything. And also, in the 4 rounds I've judged, I have never seen like a team for defense counsel, like play up this expert as like this idea of a dose. Like I've never really been a fan of the defense expert in the other rounds I judged, and so it was a very interesting take, and like it stood out to me.
Yeah, I also the round that I judged earlier this morning was it was a totally different theory. I had basically almost totally different witnesses for the whole trial, so that was to see. And so I was coming at it from a different angle. I was expecting you guys to go one route, but I think you guys did a really good job. So well done. I don't know. Also, just out of curiosity, what schools are you guys from? We've already submitted the ballots. I was just curious to see where you guys are from.
The defense is from Miami University of Ohio.
Okay, nice.
Plaintiff is from Baylor.
Oh, wow. Okay. Well, you guys, we had, I think earlier this morning, Wisconsin and Liberty University. So it's nice to see teams competing in the country. Glad you guys were able to even if it's virtually. So thank you for for coming in and for competing. You guys all did a great job. If you got any other questions, let us know. But all right, that being said, I'm sorry, did someone say something?
Yeah, I was just saying thank you for your time.
Oh, absolutely. It's our pleasure. We're happy to be here, happy to help. But yeah, I guess that being said, I think we're done for the day, done for the weekend. Congratulations on being finished, guys, and good luck with the rest of your season.
Thank you.
Thank you.